those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but everybody else may not.
Yeah, definitely.
Yeah.
So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents, the documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated?
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state. Okay. And nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order protecting. So I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time, it was Chief Judge, I believe it was Judge Brasher, who was the chief judge at the time, obtained an order to impanel a special purpose grand jury, and I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury. And so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did. Yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they use the grand jury process, the special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
Right. And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first,
Just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public. And there's, of course, a public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both, within in the system, kind of what's appropriate conduct,
right.
and also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes,
Right.
or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I want to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it. And so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to, because there's a lot of conflict issues. And so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict. And if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of this.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done
Fulton County is one of them.
Only 2. Well, yes. I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the Prosecuting Attorneys Council early on in this case, and because I was trying to figure out the legality of this. I did open records, and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what I mean. In my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18. The one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something
what
like that.
What is that statutory
It's,
rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually opened records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county, and I do know I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer, though. Depending on who you are in Fulton County, depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills. They do all of that stuff. So that's what happens at the county attorney's office.
Okay, county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole nother issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position. And I was surprised. So I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's in part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
I do actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021. Is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened. She was awarded that money September 15th, 2021. And she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of 21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes,
Okay.
that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay, so this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county.
Yes. Yes, it is.
Okay, all right. So what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help
Right.
with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval.
Okay.
So, the statute says it already. When you were asking about it changing statutes, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit just in case you had any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fonnie Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office. And he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't. And I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it. We don't have to do it. I'm a constitutional officer. So their argument was, we don't have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members. And so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for special attorney general.
Yes.
Not attorney general.
Special
DA.
counsel.
Okay,
Right.
counsel.
Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute.
That they have, once they're awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it however.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
Yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or, whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No. So, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time, and then it gets submitted to purchasing, and purchasing then pays it.
Good morning, Dr. Henninger. Where do you work?
I am currently retired. I've worked at the Fulton County Medical Examiner's Office until January of 2023.
Okay, and you mentioned that you're retired and you worked until January of 2023. How long were you overall a medical examiner?
I started in 1995 and worked full time until that point when I retired. And then in the last year, I've done a few cases, a few days a month over at DeKalb County. So about 28 or 29 years.
And what were some of your duties and responsibilities as a medical examiner?
Okay, so the duties that we have are involved with death investigation of suspicious or violent deaths. And we have investigators who collect information. They may go to the scene of the death, or they help us gather medical records and other information from the police. Then we review those. We examine the remains of deceased individuals. We often do autopsies on them. And then we review the information that's gathered and we determine a cause and manner of death. So that's kind of the first part of our job. The second part is to take the information that we have gained and share it with the community that's interested. It can be attorneys, prosecution and defense. It can be public health, be family members, insurance companies. I mean, there's a variety of people that are interested in information. So we convey that information. And so that's what I'm doing right now.
And were your duties the same on April 7th of 2020?
Yes, they're pretty similar. I mean, they're well, identical, really. Yes.
And what's your educational background?
Okay, so I started out, I went to college at Utah State University, and I received a Bachelor of Science degree. And then, and it was in biology. And then I went to medical school at the University of Utah, and I received an MD degree. And then I went in and I did an internship in internal medicine. And that was at Keesler Air Force Base in Biloxi, Mississippi. And then I practiced primary care medicine for a few years. After I'd completed my service there in the military, I went back to Utah and I did a 4-year residency in pathology. And then I did a 1-year fellowship in forensic pathology. It's a subspecialty pathology. And that was done at the up in Minneapolis at the Hennepin County Medical Examiner's Office. And then after I finished my fellowship, I moved to Atlanta and started working for Fulton County.
Okay, and you mentioned that you have a specialty in forensic pathology. Can you explain a little bit what pathology is?
Okay, pathology is a subspecialty of medicine that is focused on the physical appearance of diseases and injuries. It's like you look and see, kind of a field that's been around a lot. And it has 2 branches. One is anatomic, where you're looking at things that are, like, specimens, biopsies, autopsies, things like that. The other half of it's clinical, which is, laboratory medicine, basically. So we sometimes have some role in that.
And are you board certified?
Yes, I am.
And what does board certification mean?
Board certification means that there's these organizations that are called like the American Board of Pathology or the Surgery, American Board of, all the different specialties. Each one of these boards defines what it means to be specialized, and they select institutions that they feel like meet the requirements as far as the caseload and the teaching situations. And so you're required to attend one of those institutions, and you're required to do a certain number of months of rotations, where you're evaluated. And then when you complete that 4-year program, then you have to take a test to be board certified. It's usually a pretty rigorous test and it has a high failure rate. So if you complete all of the time that at the institution and you complete the test, then you're declared board certified. So that's what I have done.
And are you a member of any professional societies?
Yes, I'm a member of what's called the National Association of Medical Examiners. It's a group of mostly forensic pathologists, and it's a fairly small group because there aren't very many of us do this. And then I'm a member of another organization called the American Academy of Forensic Science, and it includes many of the forensic sciences, and there's thousands of people that belong to that.
Okay, and have you ever testified in court before?
Yes.
Do you know how many times, or a ballpark?
Oh, well, hundreds of times, probably. I think I'm on 26 or 27 just since I retired,
And you said that's just since you retired?
just in the last year.
Okay. And a ballpark of how many autopsies you've performed?
I didn't keep perfect track of that, but I did about 250 a year or more for 27, 28 years. So that's up, 6,000 something.
And have you ever been qualified as an expert?
Yes.
Have you ever been denied an expert?
No.
And you were qualified as a expert in forensic pathology?
That's the only thing I've been qualified in.
Okay. At this time, I would like to qualify Dr. Henninger as an expert in forensic pathology.
Any objection from the defense? You may proceed.
What is an autopsy?
An autopsy is a medical procedure and it's performed on the remains of a deceased individual. And the purpose of the autopsy is to try and determine the cause and manner of death, mostly the cause of death.
And what is the purpose of performing an autopsy?
Mainly to try and figure out why the person died or their cause of death, what mechanism, what diseases, what injuries they have that made it so that they were no longer able to continue to live.
And on April 7th, 2020 at 10:30 a.m., did you perform an autopsy on an individual by the name of Andrew Chuong?
Yes, I did.
And can you please tell the jury how the body presented? Was it sealed or
I would need to get my report, which I think you have a copy of right there.
And brings me to my next question. Did you document the findings of the autopsy?
Yes, I did.
And how was that documented?
Two ways it's documented. It's documented with a report, which I dictate while I'm doing the case, and then it's typed up and corrected. And it's also documented with photography.
Okay, and was that done contemporaneously with the autopsy?
Yeah, the process begins, the way I do it is I mean, right there, I'm basically, when I'm doing the autopsy, I'm not thinking about the grammar and the structure of the report. I'm thinking about what am I seeing? What do I want to make sure gets in this report? I just dictate it as it goes. And then later, it has to be, organized, put into a standard form and corrected, try and get the grammar and the spelling correct. So and that's a process, but it begins and the information is derived through direct observation while I'm looking at the body in the autopsy room.
Okay. Dr. Henninger, I am showing you what is previously been marked as States Exhibit 135. Do you recognize it?
Yes, I do.
Can you tell me what you recognize it to be?
This is an autopsy report for Andrew Chuong.
And is it a fair and accurate representation of the autopsy report you reviewed for the autopsy of Andrew Chuong?
Yes, it is.
And at this time, I would like to tender States Exhibit 135 in the evidence.
Any objection to 135? 135 is admitted.
Okay, and permission to publish?
You may.
We'll get that published shortly. In the interim, I'll move on to something else. Dr. Henninger, let me go back to asking you that first question I asked you earlier. Did that autopsy, sealed or unsealed?
Okay, so this body came to us in a white disaster bag and it was sealed with our medical examiner's tag, and the seal number is 1459572.
I'm sorry, Dr. Henninger, you mentioned there were photos taken during the autopsy as well, correct?
That's correct.
Do you know who they were taken by?
We have photographers that are basically, that's what they do. They're professional photographers. There's one at this time that's been there for 10 years longer than I have. And she usually did the complicated cases. And the other people that help are also trained. So I don't know for sure who took these photographs. I'm probably like 80 or 90% certain that that was the one that's done it for the longest.
Were you there when they?
Yes, I tell her, this is what we need.
Okay, and I think you may have gotten into this a little bit earlier, but what is the purpose of taking those photos?
The photographs are basically a picture's worth 1,000 words, and it's basically to help me remember and to see, also to help me explain these injuries.
Okay, and I'm showing you what's been previously marked as States Exhibits 136 to 159. Do you recognize them?
Okay.
Judge, can we be led?
Yes, I do.
All right, if we can add Ms. Willinghammer and someone else from the state as a co-host to the Zoom call.
And you said you do recognize him?
Yes, I do.
What are
These are just a few of the pictures that were taken at the autopsy.
they? And are they a fair and accurate representation of how the body looked when the autopsy was performed?
Yes.
Okay. And Dr. Henninger, what is the purpose of the state would move to tender states exhibits 136 to 159?
Objection 136 through 159. And then without objection.
Thank you. And Dr. Henninger, what is the purpose of assigning a case number?
Okay, well, we do a lot of cases and some of them resemble each other and I have a hard time remembering the cases I did last week because there's so many of them. So the case number is essential for us to not mix them up with other cases, which is really easy to do if you don't really keep track of these case numbers.
Okay, and so is it then unique to that case you mentioned, so you don't mix them up?
Yes.
Okay. Okay, and Dr. Henninger, what was the reason you identified for performing the examination?
Okay, the reason for performing examination is basically, an autopsy is generally something that requires the permission of the family in a hospital situation. So you have to go get their permission. In certain cases, we are allowed to do an autopsy regardless of their permission, or even if we even know who they are, to get the permission. And so, this is regulated. And so the reason for examination, I'm putting forth enough information there. It's kind of summary information that I know at the beginning, but to basically justify that I can do this.
Good
under
morning,
the,
ladies and gentlemen. Good morning.
Authority of the state and not not because the family said
Make
I
sure
could
you
or
like,
couldn't.
subscribe, and share.
And so the
this
reason for examination
live
is
coverage
we were
of
told
Austin
there was
Chuong murder trial.
stabbing and
This is the medical
altercation.
examiner giving testimony right
that's
now.
enough. So that we need to look into it.
Okay, and is it common then for you all to receive that request?
What happens, I guess it's not really a request, it's basically what we do. I mean, we're called by people, the police, hospitals, when a death occurs, and we do have the power to, what we say, decline it if we think it's not something we're going to be interested in. But basically, they call us, and that's what starts the process.
Okay, and okay, Dr. Henninger, let's walk through the summary of your findings. Can you go through that area and kind of explain to us what your findings were in this autopsy?
Okay, and
Unfortunately, I can't put it up on the screen yet.
okay, most of the time of my career, they weren't able to do that, but recently.
You're still not a host? All right, paging Mr. Derberry in the back. We need to add as a co-host. And what is the?
It's my name.
All right, Ms. Willingham is a co-host.
Okay,
All right, Ms.
so-
Willingham, you can either wait a minute or if you feel comfortable going forward, whatever you prefer.
Okay, it looks like we're connecting, so if you give us just a moment, Judge. Oh, yeah.
Okay.
Do you want to close and open back up full or? Okay, Dr. Henninger, scrolling to the section of your report on page 2.
Okay. Okay, so,
And this is States Exhibit 135. What was you've already discussed, I'm sorry, the reason you identified for performing the examination. So let's go down into the summary of findings. Starting there with the first one, can you kind of walk us through those findings?
Okay, so the summary of findings is kind of, I try and get it down to one page and have just the really important things on there. Okay, so, and I organize it generally from top to bottom, or just sometimes whatever makes sense at the time. Okay, so I have like 9 categories there. The first 7 are injuries. There's 3 sharp force injuries and some superficial injuries on the right side of his face. There's a stab wound near his right clavicle or collarbone. It actually goes into his chest, to where it gets to his lung. There's the most severe of these is the stab wound. It's on the sternum, and it goes into his heart and into one of the large vessels that comes out of the heart.
And the doctor's describing
Then there's a group
Andrew
of superficial
Chuong's
injuries on his right
injuries. This is
shoulder.
the father
They're not
of
very severe.
Austin Chuong, charged with murdering his
There's
father.
some cuts and abrasions on his hip and his abdomen. These are less severe. And then going over onto his back, there are 6 more stab wounds back there. These hit ribs or just
morning,
weren't
be
deep
more,
enough
shorty.
to get
Good
into the
morning.
body. And then there's some more superficial injuries. One of them is actually the largest of these injuries. It's in the back of his leg. But it didn't do any, didn't damage any major blood vessels or, Okay. And then there's a few other little problems that he had. These are natural diseases. He's 55 years old. He's got a little bit of heart disease. Heart's enlarged, dilated, and kind of thick. He's got some congestion, and on the microscope, a little bit of early kind of emphysema starting to come in. Just common people once they get older. And he's got a kind of an interesting little thing. We call these fascinomas. They're just things you find that are kind of fascinating, but not very relevant. He has a mucus cyst in the back of his throat down the epiglottis is the flap of the throat that closes the esophagus where, food goes while you're breathing, and then it opens so you can swallow. And
Pretty
it's right
graphic.
there. There's a
Pretty
little
graphic.
It's a mucus cyst, which is benign and doesn't cause death, and it's not really a problem. I don't know if he knew about it or not. They can be removed pretty easily.
Faith, look at part 1.
And the last thing we do is that we look at
live.
his
Calm down,
blood for
Faith.
other
Just watch part
substances,
2, part 1, and
like
then go back to part
illegal drugs, things
2.
like that.
Watch
or
part
alcohol.
2 live.
And that's called
and then go back to
toxicology,
part
and there
1
was none
afterwards.
of those that were found.
Okay, and Dr. Henninger, I know we went through the summary a bit. Would the photos that were taken be able to help you better explain some of where these injuries were that you've pointed out?
Yes.
And okay, taking a look at,
You raise your
I
kids.
was about to say, I'm gonna have to stop
You
sharing.
raise your kids, and this is the reward that you get.
I'm gonna stop sharing
Well,
just for a moment, Dr.
this is the
Henninger, so I
reward
can
he got.
maximize the screen, and then I'll open it back up. Okay, and starting with State's Exhibit 136. Oh, I'm sorry. That photo that you were just looking at, Dr. Henninger, you talked about a seal earlier.
Yes.
Is that what you're referring to?
Yes, this is the first picture that we take. And there is this tag here. It's prepared by investigator this case is Brian Rentz. And he's kind of a retired detective and one of our lead investigators. And it has the case number on there. These handwritten, the name, the information that we have. And this 1459572,
Unfortunately, I
which is
used to
that
shoot
seal
crime scene
number.
photos,
And that seal goes around the
and I could tell you,
zipper, the bag,
wasn't
the body bag is
wasn't a fun
white
job.
and it has a black zipper and you can see the zipper and that's somebody's thumb, probably his. And basically he puts this on when he puts the body in this bag and seals it. And then it's transported to our office and kept in the cooler until we do the autopsy.
Okay. And taking a look at this next photo, Dr. Henninger, what are we looking at in State's Exhibit 137?
Okay, this used to be the first picture we took before we started doing these seals, which you could see over on the table.
And I want to warn you,
next
this
thing
is
we
very
do is
graphic.
we
So if you
unzip
can't
The bag,
take this,
and
you
we
might
take a
want to leave
picture.
now.
and we put this thing, this tag, it's got the number on it. And that is also sorry.
You can keep discussing that
Okay.
picture.
Okay, what that picture shows is there's these clothed. It shows that he doesn't have medical intervention. And then it kind of gives you kind of like a ballpark, his his size, his age, things like that.
Okay, and moving on to State's Exhibit 138, what are we looking at here?
Okay, this is the back of the shirt that he was wearing. And those little arrows that are kind of white and yellow, they are holes in the shirt. Okay. Now, some people have holes in their clothes for any variety of reasons. But these are not perfect, but they're kind of in the same pattern of the stab wounds. So it's often important to look at this outer surface of whatever injury there is. There might be things on the shirt that aren't on the body that relate to the injuries. I don't see anything interesting on these other than that they're just holes in his shirt.
Okay, and Dr. Henninger, you mentioned in the summaries that you discussed earlier, there was a portion that you mentioned that there was a group of six. Yes, that there were a group of 6 stab wounds on the right and left side of the back.
Mhm.
Is that what's okay?
Yeah, that's what that is. And I numbered it 6, just coincidentally. But yeah.
Okay.
So this guy went
And-
crazy on his dad.
In this next photo,
Warning, ladies
what
and
are we
gentlemen.
looking at
Warning,
here?
ladies and gentlemen.
Okay, this is kind of an ID photo that we take. It doesn't, sometimes we put the number in it, and it's just a picture of his face. It does show some of the injuries on his face. They are on the right side. One of them's up by his right eye here. And some of them are down around his side of his mouth, on the right side of his mouth. These are cuts, and they're from injuries from a sharp object.
And Dr. Hendra, I noticed you were up wanting to point. I have a
Oh.
little.
I used to,
There's a little
yes,
laser pin on the front, so you just push that button right there.
that's nice. Okay.
Okay, and moving on to this next photo, I know you just discussed some of the injuries in the face. Is that what you were pointing to, just closer up?
Yeah, this I think's a better picture because it's actually focused in on, and it's got the face in the right plane where you can really see these injuries. They're this
Like
thing
it's
just
work-
worked,
okay.
didn't it? Does it not work on the screen?
My apologies, it looks like it may not work on the screen.
That's amazing.
Okay. So my apologies, you may still have to get up, Dr. Henninger. Sorry about that.
Okay.
Okay,
Fine.
taking a look at this next photo.
Okay.
Is this just a different angle?
Yeah. The one before showed these kind of, in the center and focused on this and these. Now these are sharp. they're not from scratches, they're cuts. And then there's, this is an abrasion. It's kind of related to a scrape. Okay, so there,
Well, this is his father.
Right, I'm gonna zoom
Let's-
out just a bit, so maybe that'll help actually show the whole picture. That might make it just a little bit easier for you. My apologies.
And ladies and gentlemen, I see this all the time in murder cases. This happens all the time in murder cases, as far as the scientific evidence is being shown to the jurors. And it usually follows a certain pattern. First, you get your law enforcement investigators and officers who've came upon the crime scene, and now
Okay,
you
is
bring
that
your
when
your
it pops up, is that a little bit easier for you having the whole picture
DNA
up at one
experts,
time?
yeah, that
serologists,
helps.
Okay,
blood analysts.
okay.
Still
So
not-
now, taking a look at States Exhibit 142, what are we looking at here?
Okay, so this kind of helps localize, so you know where injuries are. Sometimes if you take a close-up picture of an injury, you don't know where it is. So the next injury on our list was this stab wound that's over the right clavicle or the
Mm.
collarbone here.
Oh my
And you can
goodness.
see where it is kind of related to the other injuries.
Oh my goodness.
And then there's a group of superficial injuries over on his right shoulder.
Moving to States Exhibit 143.
Puncture wound. Stab.
Okay, so this is the stab wound on the collarbone there. And
You can hear me now.
we're interested in looking at stab wounds and seeing what information we can derive from them. A simple stab wound might just be like a cut, or just if a person uses a single-edged knife where it has one edge is sharp and the other is a rib that's strong, you'll get an injury where the sharp part of the knife will be really pointed, and where the dull part of the knife goes in, it will be more squared off a little bit. Or if you hit with hilts,
So
the knife
he
has
stabbed
hilts,
father in the
on
front and then
handles.
starts stabbing him in the
If they,
back.
so the stab wound is with enough force, it may cause abrasions. Also, people tend to not just sit still while they're being stabbed. They often move around. So you'll get some features of that. So when I look at this stab wound, this right here and this down here are interesting. The thing they really want me to do is to tell you exactly which knife did this, which I can't do. But what kind of an idea of
This
what it
fool
looked
want to
like.
represent himself.
And most knives are enough alike that they make similar wounds. There's a lot of overlap. But that's nonetheless, the lower part of this is kind of squared off, and it's an abrasion. Okay, and I don't know for sure on these, but that might suggest the hilt. And if the knife's coming in at a pretty steep angle, the lower part of the hilt will hit the body first. Okay, the other side, it's kind of hard to say. That's a cut. It looks like a cut. It could be a abrasion from tearing, but that could be the sharp blade. So that would suggest the blade is up. But it could just be from tearing the skin. So I'm not sure. But that's the purpose of these pictures, and that one's kind of better than average. We try and do this, but it's not as accurate as that we really would like.
Taking a look at States Exhibit 144. What are we looking at here?
Okay, this is the stab wound on the chest, the sternum, that went into his heart. And you can see the other ones kind of see where it's kind of localized.
And you mentioned on his sternum, it went into his heart. Would that be consistent with a blade that's more than 3 inches?
Okay, that's the other thing that we want to know from these wounds is it seems like you could just sort of go, well, let's see, this wound is 3 inches, therefore the knife's 3 inches. Well, The problem with that is, first of all, the knife may not go all the way in. You could have a knife that's a foot long, if it only goes in 6 inches, you wouldn't know it was a foot long. You can also cave in organs. The chest cavity, the whole point of CPR is to create enough distance that you're compressing the heart, for CPR. So you can cave in a chest, several inches, abdomen even more. So there's that problem. So you can have a 3-inch knife, make a 6-inch deep wound. So that's kind of hard. But if you think about how big he is, the heart sits right here.
And the reason why I'm covering
it's-
this is
There's
because
probably
it
less than
happened
an
in my
inch
community.
of skin and muscle and
This
fat
happened in my
on
community.
him. And the sternum that goes through this bone is about as thick as this thing. It's bone, and then the heart sits right there. So it wouldn't, that's really close to, it's right above the heart.
And you mentioned that a 3-inch blade could make a wound deeper than
Yes.
3 inches. Can you tell whether, based on how deep you just explained that the knife or that the wound itself was, would you be able to say whether the knife is over 3 inches?
No, not definitively. It could be smaller, it could be larger than 3 inches.
And taking a look at this next photo, is this the same wound? It's just
Yes.
a closer? Or
Yes,
is it a
and
different one?
this is the same wound. This is unusual because it has an abrasion around it. Here. That's from scraping. And that is because it had to be a lot of force to do that. And that force, this is kind of interesting, and you'll see how interesting on another ones we'll get to, but this goes not around the sternum, it goes through it. And the sternum is the bone is stronger than wood, especially when it's a living bone, it's somewhat flexible. And so this blade went through his bone, the sternum. Like this right here is, well, it's thinner, but it's metal, so it's probably a little bit stronger. But if you thought of something like this, it was made out of solid plastic that was 1/4 of an inch thick, and some plastic that's the same strength as bone. And that took a lot of force to do that. And so, and then once it gets through that bone, it can go however far it goes.
And taking a look at State's Exhibit 146, what are we looking at here?
Okay, this is, there's these 3 injuries on the right shoulder, and they are, make sure that I get these things. They're basically a combination of abrasions, superficial abrasions, and a cut. And so there's been the blade of the knife scraped right here. And I don't know, these are more abrasions. And I don't know exactly how those happen.
And what are we looking at here in State's Exhibit 147?
So now we've gone down onto his right side of his body on just below his waistline at top of his hip. And there's a cut there. And it's fairly long, doesn't go very deep.
And in State's Exhibit 148, what are we looking at here?
This is a long, very thin, very superficial injury that would require a sharp object to make it. like a cut.
And looking at State's Exhibit 149, I'll rotate that for you. What are we looking at here?
Okay, these are 6 stab wounds on his back. Excuse me. And you can see how they are sort of like the shirt, but also sort of not. Okay, and that's because clothing can move around. I can't tell the order these occurred. They all look pretty typical stab wounds. All of them are going from back to front, but they have different directions after that. Some of them are going upward or downward or right or left. And
This is
interestingly,
awful.
they
This is
don't
awful.
get through the bones there. I mean, this one's right on the spinal column, and that one, and these others are either over bones or ribs. So they
The
actually
jury
don't.
is looking at these pictures, and I know
causes-
they have to be in shock.
They do contribute to because they bleed, and his ultimate cause of his death is all the bleeding, but they don't contribute as much as being stabbed in the heart. And we can kind of look at these and try and figure out if we think what kind of a knife it is. And some of them have little tails on them, where they're cuts at the end. These are probably the sharp edge. Like this one's pretty good that's pretty sharp there, and that's kind of squared off. So that would suggest the edge of the blade is here, the knife is there. And then if the knife is that wide, that would make it, but if the knife is narrower, you can just
I'm wondering if this was
across.
a
So that,
premeditation.
again,
Did
that's
he
another
plan this?
factor that we want to be able to look at. It doesn't work very good, but you can make a long cut with a short knife. And we can kind of go through and look at each of them, and they're not perfectly clear on all of that. And I don't know the order that they occurred.
And taking a look at State's Exhibit 150.
So this is the one up on the shoulder. It's furthest left. It's kind of got a sharp corner here, and there's a little abrasion there. So the blade's probably downward.
And for
on
those who are
that.
joining, Austin Chuong told the police that it was
And
someone
151.
else that did this. It was some
This
stranger
one
that
looks
did
like
this
there's a cut there.
initially. So the
cut
jury's going to hear
square,
that
so
because
the blade's
he
probably down.
clearly tried to distance
If
himself
I
from
had
killing
this
his
one by
father and
itself, the only wound on
savagely
his
beating his
body,
brother with a baseball
probably
bat
say, I don't
and
know.
stabbing his mother.
But since it's they're right next to each other, there's kind of like guilt from association. So if I had to guess, I would say that's the same as this, but it might be the opposite.
And State's Exhibit 152.
I think this is sharp. And that's squared, so I think the blade is downward on that one. And this one we talked about, I think it's a little bit closer for it.
Yeah, one brother. And I believe
And
he
where are
has a
we
sister
looking at
as
here
well.
in State's Exhibit 154?
Okay, this is the back of his leg. It's his left leg, he's laying flat. You see the fingerprint stuff on his hands. We fingerprinted him. He didn't get that washed off before we took this picture. And this is
He's
just the
about
biggest
20,
injury. And you can pretty much see
24
all
right
of it.
now.
It
He
doesn't
was
go very deep, and it
18.
just opens up the skin.
he's 24,
The
25
fat
right
is kind
now.
of yellow. And then they're getting down into the muscles, the linings of the muscles are called fascia. That are on top of the muscle. And that's a big cut.
And there is a warrant,
And it's
an
kind of hard to tell
arrest
which way that is.
warrant out
The
for the
angles
mother
on it.
and the brother for a material witness warrant. Not it's a
And
material witness warrant.
that's a closer
warrant.
up
Basically
Version
meaning
of that, are you
it-
able to tell from that
they are
picture?
looking for them because these are two of the
That was
witnesses
sharp,
to the
and
crime.
that's kind of squared off, so maybe that way. But it's,
And moving to State's Exhibit 156.
hey, this is a very minor injury. It's on his knee. It's kind of interesting, at least to me. I'm trying to see if I can get more information out of this than just an abrasion on his knee. It is square, or kind of got two corners on it, square. It's kind of has abrupt and pretty deep and then superficial. And so I'm trying to imagine what kind of an instrument would do that. And if I walked through the hardware store, I could probably pick out a bunch of instruments.
Late 18,
If
19
I
years
walk through
old.
the house, I don't know, handles or stuff. But that that's getting to be what we call pattern injuries. And a really good pattern injury is when you can take the injury and match it to something and convince people it has to be that injury had to be caused by that object.
My guess
And I'm
is
not
he
there
fell
on
when he
that, but
fell, he
it's
may have hit
it's
something
more like a
that may
pattern
be a
than
part
just,
of the floor or something.
usual abrasions. And I don't have a good answer why that injury. I mean, it's an abrasion. It's not very severe, but I don't know what caused it.
Okay, and looking at 157, is that just a closer up version of that?
Yes, you can see how it's got pretty deep up on top, and then it's kind of fades down. Something that's about this size right here, at least partially.
And looking at States Exhibit 158.
Okay, this is another kind of ragged cut, and it's on his ankle, and that's his left ankle. His toes are down here, and the rest of his legs up there. This is our tag, and we also put these on just so we don't mix him up with other people.
And States Exhibit 159.
This is another minor injury on his foot. This is on his right foot, right here, in this area, and it's very superficial.
Okay, and taking a look at page 4 of your report. Well, first, I'm sorry, before we get into page 4 of your report, can you tell us how many stab wounds were present in total?
Depends on how you count them. I lettered them up to 24 letters of the alphabet, but I grouped some of them. So, and then some of them are abrasions. And so there's at least 24, and probably, I don't think there's more than 30. I don't think I grouped them that much.
24 to 30.
Okay.
My
and
goodness.
Of the injuries that we discussed, which ones would you say were contributors to his death?
Okay, so I guess it depends. I mean, it's not like a black and white or binary thing, where this one's didn't contribute, this one.
I mean, the man could have went a heart attack.
I mean, you could argue every drop of blood counts or whatever.
Absolutely.
Some of these are so minor.
What
that
kind of
they're,
question
very
is that,
little
prosecutor?
contribution. And some of them have made some contribution. The one in his chest was the biggest contributor to his death. It went into his heart, caused a lot of bleeding there. The one up on his collarbone also went into his chest. It got his lung. The lung bleeds a lot. Also, once you puncture a lung, your breathing doesn't work. So he's only breathing with one lung. You have to have your lungs work on negative pressure so that when you take a breath, when you inhale, what you're doing is you're increasing the volume of your chest, which decreases the pressure and it sucks the
Fake.
air in.
That's why you're
Well,
here.
if you puncture
Now
that,
you can
it
find
won't
it.
work.
This is a
And so he doesn't
story
have a lung.
that
One
originated
of his
out of
lungs is
Alpharetta,
disabled from
Georgia.
that stab wound, so he's not breathing.
And this is
The
a
problem with
story
bleeding
that
is
had
that blood
shocked the
carries-
community.
Well, the first problem with bleeding is that it
The
carries
crime rate in
oxygen,
Alpharetta is
so you
very
run out of
low.
oxygen. So
This
now
is
you've
the
got a lung,
suburbs
so
of
it's only got
Atlanta.
half as much oxygen being loaded into his blood, and you've got it all being pumped somewhere where it's not doing any good. So they're both of those are contributory, pretty serious. The others are the ones on the face might bleed pretty bad. The one on the back of his leg, that's big enough, it'd probably bleed a lot. So it's kind of a continuum. I guess it's kind of like a classroom of rowdy kids, and you can pick out the two that are the worst, but the others are contributing to different degrees.
Okay, and now moving to page 4 of your report, let's take a look at sections or at letters under the injuries of the anterior. Let's look at letter F and H. We can start with F. And can you kind of explain that injury to us?
Okay, F is my more detailed description of that injury on his collarbone, right? clavicle right here. And I write where it's at. And then I kind of describe it. And then I talk about, it gets into the chest cavity, it goes through the first space, the first and second rib space there, it doesn't hit the rib. And then it creates a teeny puncture on the right upper lobe. It's like these, this is 2 and 3 millimeters. So it's not very severe, but it does open up the chest cavity, and that will bleed. And then I put directions on it. So it's from his front, his back, and downward, like this.
Okay, and taking a look at H, I think this was one you explained before as well, but does this section help you explain it a little more in depth?
Yes, this is the one that's on his front of his chest, precordial. It's kind of in front of the heart. And it's, got how far away it is. It's oriented kind of diagonally on its size. This, the one I thought was angulated versus squared. And then I think I was not supposed to write on this report. This is me when we were talking about this earlier. And so it goes through the sternum and right where the fourth ribs attach. And it's this kind of interesting how the wound may be kind of diagonal a little bit here to 8 o'clock. But then when it goes through the sternum, it's horizontal. Okay, so there's movement going on. And then I measured the things of the sternum. That's about a centimeter. My fingernail just happens to be a centimeter wide. It's very useful sometimes. And this is like 6/10 of that, like a little bit more than half that. So it's about that thick, the sternum there. And then this tells what it damaged inside of his chest. Okay, so there's this sac around the heart that protects it. It went through that, and then the space inside of that sac is called the pericardial sac and the pericardial cavity. There's blood there. There's a large vessel that comes out of the
Okay,
aorta.
guys, you're in here.
Or comes out of the
Smash the
heart
like
called the
button.
aorta.
Smash the like
It
button.
hits
Smash
that,
the like button. We
ascending
need
aorta,
that
and it's only 3
engagement.
centimeters, which is 1.5 inches above the valve with the heart. So it's right out of the heart by 1.5 inches. Okay, and by that point, it's vertically oriented instead of horizontal. The heart, if you've ever seen I don't know if you've looked at the YouTube, they have pictures of open heart surgery while the heart's beating, and it's doing like this. It moves a lot. It's really amazing. That's why they have to stop it to do surgery on it. Anyway, so it can move. Just injuries through the heart are often not the same direction as the ones around them. So that's pretty much expected. And then it cuts open the left atrium. There's the 4 chambers of the heart. That's the one on the left that's higher, the smaller one. And then the chest cavities are filled with blood. The chest cavities are not separate from each other. And so if you put like a gallon of blood on the right side, and then you take the body and roll it over, like what they have to do to move it, the blood can go both sides. So even though you might expect not very much blood on the left side, there was a lot of blood on both sides.
And going back to page 2 of your report, can you explain to us what does the cause of death mean?
Okay, the cause of death is the basically it's the whatever change or injury in the body that makes it no longer able to function. And I like to think of cause of death as like chapter headings in textbooks. So in a general medicine textbook, you might have a chapter on heart attack or pneumonia or lung cancer. Those are causes of death. Forensics books, they might be like gunshot wound or stab wound, drug overdose, drowning, electrical shock, things like this. Those are the causes of death.
And what is the manner of death mean?
Okay, and the manner is homicide. And manner, we use that word in our own little special way. Okay, because it's kind of got a general, kind of vague general. And what we're doing, this is for public health reasons. So we look at each death and we look at the autopsy findings and we also look at the circumstances that we know about. And we try and take that death and put it in one of 4 categories. The categories are natural deaths, which are the majority of them. And those are due to problems inside of the body, medical problems. All the subspecialties of medicine exist to deal with those. And then there are accidental deaths. These are injuries that are due to something outside of the body, out in the environment, that's kind of unforeseen or just kind of happened. And then there are suicides, which are inflicted injuries intentionally by a person on themselves to cause their death. And then there's homicides, which are injuries that are intentionally inflicted on another person. And then we have a 5th category for the undetermined, because there's some situations are kind of boundaries between these, or mixes of these. Life is never simple enough to put it in 4 boxes. So we have undetermined for those cases. So in this case, this is not a natural death. It's not an accident, and it doesn't appear to be self-inflicted. So it's a homicide.
Okay, and I think you answered. Well, you just answered why you ruled it a homicide. Nothing further.
Mr. Chuong, any cross-examination?
So you said that there was stabs near the clavicle that goes into the chest cavity, correct?
That's correct.
And the stab near the sternum that goes into the aorta and heart, correct?
Yes.
And then the one that goes through the sternum's hard and thick, correct? You said it's like wood?
It's a bone. It's
Okay.
like a bone, and it's about this wide, and it's about, half as thick as my thumb. So it's, your skull in some places is thicker than that. Right here it's thinner, but kind of the thickness of the skull right here is similar to it. So it's bone. So a bone is like, you can think of bone and wood are 2 biological things, but the difference is that bone has minerals in it that wood doesn't. It also has elasticities and so it can flex a little bit more. Wood does too, to some degree, but so it's kind of an approximate model, but it's not perfect. I think it would be harder to stab through wood. Through bone than wood, but at least has hard.
So there were some deep stabs, and you said yourself it takes a lot of force and strength to make those stabs, correct?
The one through the bone wood, the ones on the back, the strongest thing it has to go through is the dermis, and this is like leather. And so
Okay,
the
watch
skin leather is
foolery
kind
going
of,
on.
you take a typical shoe, the leather on the shoe, like even this plastic it's kind of thick like that. So you have to get through that. The skin above it doesn't have very much resistance. And below that, there's fat, which has very little resistance. And then muscle, which is like, you're pretty familiar with muscle because it's basically like raw meat. And then internal organs tend to be softer. The heart's as strong as it's a muscle. So those are the forces that are needed to do the stab wounds.
So a person who is strong would have to make those wounds, correct?
Well, yes. How strong? Then we get into some really difficult calculations and biomechanics that has so many variables that it's hard to say. But as far as if you think of strong as in a relative strength, I don't know how many members of the jury are strong enough to do this, but probably more than one. Probably several of them are strong enough. And then it depends on how motivated they are.
And
The adrenaline
there's
is
a
gonna
lot of
give you
stabs and
strength.
cuts
You know
around my
this.
father's body, all from different directions. You said, correct?
Yes.
And there were all different types of cut and stabs, correct?
Well, there's a bunch. Yeah.
Some deep, some shallow, and then there's some on top of his body, and then there's some on his back. You said about 6.
There were 6 back there. Yeah.
And then some on his front, and then some on the bottom of his body. the one on his thigh,
Yes.
pretty bad, you said?
Yeah, well, it's big.
So ultimately, the reason he died was bleeding.
That's
Right?
correct.
So if someone was near him and could have helped him, he could have lived, would you say?
You
Oh,
could
that's
have
a
helped
good
him by
question.
not doing
Okay,
it.
So
The heck
the way
you
they
talking about?
hypothetical, same question is, if he was stabbed on the front porch at Grady Hospital with the best surgical team in the country ready to go, could they fix this? This has got two pretty severe injuries that would have to be fixed at the same time. It would be pretty hard. If you talk to the trauma surgeons or optimists, they might say, oh yeah, maybe we can fix that. But I've seen a lot of injuries like this that didn't get fixed, that were in the emergency room. We're really close. So it's possible. And the trauma surgeons might say, well, yeah, maybe, but, it would be heroic and have to be fast because he's going to bleed to death in a few minutes.
Do you think it was, since you said that the wounds in the back weren't as deep, correct?
Well, they didn't get into his chest cavity. They
And
they didn't go into his lungs or his heart. They just stayed in his muscles.
is there a lot of obstruction in the back?
Well, the ones, some of them are right over the spinal column. So there's those. Some of them are ribs. So about maybe a third of the area back there's got ribs.
Oh my goodness.
And then
this
there's
guy's
the
really talking about
scapula,
his
which is a
own
big
father's
wing
injuries that
shaped
he
bone. It's about this
caused.
big. It's triangular, and it's thinner. People can often get through it easier, but it's the top of it's got big thick ridges on it, so it's kind of like a rib up there. So just by coincidence, these 6 stab wounds didn't hit a place where they would go through the bones.
Do you think it'd be possible that there could have been 2 attackers since some of the wounds are shallow and some are deep?
Boy, if you
Well,
don't sit your-
I wouldn't, the second half of that, I wouldn't agree, but I can't tell how many attackers. I mean, there could be, if I count up to, if I say there's like 25 wounds, there could be 25 people doing that. It'd be seem kind of ridiculous, but there could be 1 or 2 or 3, the more, probably the less likely, but it's possible more people could. And they could, maybe one would do one thing and one do the other, but they could both be doing similar things.
So he's alluding to maybe the
Thank you.
mother and the
Thank you, sir.
brother did.
No more
this.
further questions.
And redirect Ms. William.
Yes. I'm gonna pull back up your report. Just give me one moment to share my screen again. You just testified, Dr. Henninger, that a lot of the bleeding contributed to the death. Per your report, what is the listed cause of death in this case?
My hearing was
I'm sorry, per your report, what's the listed cause of death in this case?
listed is the word. Okay, the listed cause is stab wounds of the chest, which would include the sternum and the clavicle. And then this gets into different people do different things. You can put this all together. You could say stab wounds of the torso and extremities, or you can list these other ones as significant. And maybe some doctors would say, oh, I just ignore those, So that's other significant conditions based on my opinion. The listed cause of death is stab wounds of the chest.
Okay, and I know you testified that that the bleeding, I believe the question was, the cause of death was the bleeding. So that's what I want to clarify. You've acknowledged in your report that it was the stab wounds of the chest and that other significant conditions were stab wounds of the torso and extremities. And then earlier you also testified that all of those things caused a lot of bleeding. So is that how you're classifying it?
Yes, can kind of line them up by severity. And the one through the heart is at the front of the line. The one that punctures the lung is there right next to them. And then these other ones are kind of based on how much they bleed the face, the big ones, then the little ones. And so they're all contributing a little bit. But the ones at the front of the line are doing most of the contributing to his death.
Thank you.
Any recross on those points only, Mr. Chung? Ms. Willingham, can this witness be excused?
Yes.
Thank you, doctor.
Yes.
Statement calls next witness.
Judge, with respect to the state's next witness, state does not have the next witness to call, but there is an issue that I would like to take up for your honor out of the presence of the jury with respect to the state's finishing their case.
All right. So members of the jury, I think we need to take 10 to 15 minutes, and I hope to be back with you shortly.
All rise for the jurors.
All right, guys, what do you think? What do you think about this? This cross-examination by the defendant is crazy. It's crazy. The fact that he is able to discuss the merits of the stabbing and the likelihood that it could have been two people. I get it. The mother and the son is on the run tour right now. They're not trying to be brought in as witnesses. They're not trying to be brought in as witnesses right now. There's a material witness warrant active in Fulton County for the mother and the brother. So now, is this a concerted effort? Did the mother, brother, and the defendant all agree on them not showing up? I don't know. The timing is just like, this is a crucial case. Those DA has investigators that they should have secured them. And now what's going to happen is when they're caught, now they're going to have to give testimony. Because now if the jury by a miracle find that he's not responsible for the killing of his father, which I don't think that's going to happen, because he's not a very, while he sounds smart, but then Jeffrey Dahmer sounded smart as well. So did Charles Manson. So did many other serial killers. So I don't know. The closing argument is going to be interesting. It's going to be interesting, and how he's going to wrap this around. We don't know right now, as I speak to you, ladies and gentlemen, if they have actually found the mother and the brother. So this is crazy. We don't know that yet. We don't know whether or not the mother and the brother have been found, because the fact that they're not there, and he's kind of alluding to the jurors that there could have been two other people who created this 24 to 30 stab wounds. When did they do it? Remember, there was DNA on the cigarette pack of 3 individuals. The DNA of the brother, the mother, and him. How would that happen? We know all 3 of them didn't handle the cigarette pack. So the mixture of the bloods gave the DNA analysis, showed that the DNA analysis came back to 3 people. Right. The science is not on the kid's side. The science is not on the kid's side. And if they find guilty without the mother and the father being present, it's because the science is what the jurors are going to look at. But what I thought was kind of eerie is to watch him look at these photos and is able to even give a cross-examination. If he actually did the stabbing, then this guy's cold-blooded. Cold-blooded. You're cold-blooded. You raise your kids. Let me tell you something. They lived in a very affluent neighborhood. They lived in a very affluent neighborhood. The houses were over $400,000, close to $1 million. It's Alpharetta. Anyone knows anything about Alpharetta knows that the houses are very expensive. So you are living under your parents' roof, eating their food, sleeping in the bed, using their water, you haven't missed a meal. You're getting all the luxuries, but you're mad because your father didn't buy you a house and he bought the brother one, allegedly. It's crazy. It is crazy. This is why you don't spoil the kids. What's that saying go? Spare the rod, spoil the kids, spoil the kids, spare the rod. I forgot that saying, but I know you see it growing up. I mean, the stabbing was it was of rage, and he started talking about, well, can the strength of someone? Well, the adrenaline will give you strength to pick up 10 people. If your adrenaline is so high, you listen. If that adrenaline goes, oh, you going? Yeah, you're gonna get super strength. You're gonna get super strength. You was a Superman stabbing your dad, the man who cared for you. Yeah, he ain't gonna do well in if this case goes south for him, he's not gonna do well in jail. He's not. He's not gonna do well in jail. He's facing life. Life. He's facing life. They said the mother went up north. They have reports that the mother went up north. How far up north? Did they go to New York? Did they go to Canada? Where did they go? They ghost. They're probably tracking their phones now. They probably got the throwaway phones. They're doing everything for them not to have to come in. Why would you not want to testify against the person who killed your brother, your father, and stabbed your mother? Why not? This thing is getting deep. And it all leads back to money. Money, which is the root of all evil. Why did they run? That's a good question. Did they run because they don't want to testify against the brother, or they ran because they may be complicit in the death of the father? Well, we don't know that. We don't know the answer. We won't know because they on the run tour right now. We don't know why they run. We don't know why. Are killers on the loose? Are killers on the loose? We don't know. All right, ladies and gentlemen, I gotta get back in the courtroom. Let's see what's happening. Let's see what's happening. We're gonna go to the hearing involving hold on a second. Let's see where we at here. Stand by. We're back.
You need to present those witnesses, and we may move forward without them. And so if they are able to get their witnesses here, it's going to be as rebuttal evidence. And so at this point, based on the evidence as it stands now, it would be your turn to make that decision. That's fine. So in 10 minutes, I'll come back. And then the only question I'll have for you is, do you personally want to testify or not? And regardless of that question, do you anticipate having any other witnesses or any other evidence that you plan to introduce? All right. So we'll be back at 11:10. Be in recess.
What just happened? Let's see what just happened.
Yeah,
Go in the back.
Deputy. I know those are the things he needed to sign.
Judge.
Right now, we ear hustling. Okay, let's look at what just happened here. Stand by. Stand by, ladies and gentlemen. Let's just see what just happened here. Let me bring that back. Stand by. I want to see what just happened.
Through the manifest necessity of their testimony and whether all the
Hold on a second here.
is essentially requesting, if not now,
and a request based off of our.
Okay, hold on. Jury's just left the bench.
from
Yes,
this
Judge.
morning, or okay, how about it?
Yeah, there was, I guess, an analysis given what was anticipated as the state's next two witnesses, Miss Jenny Fang and Mr. Eric Chung, and a request based off of our efforts to locate those witnesses for a continuance. I wanted to supplement the record and supplement the state's request within the alternative, the court to consider a mistrial. My review of case law in this instance for a state requested mistrial does allow, obviously, the court has broad discretion to grant a mistrial under those grounds. I am pointing to specifically Spearman v. State, which is 278 Georgia 327. That is a case in which the defendant, in his first trial, a mistrial was granted for the state when they were unable to produce a witness that was under subpoena due to the witness actually being involved in a car accident and being unavailable because of physical hospitalization.
So the prosecutor's asking for a mistrial.
In this
Stand by.
instance, although there is not a specific kind of physical condition that prevents these witnesses from appearing, there is the unknown or unforeseeable unavailability, if you will, of these witnesses. Both witnesses were under subpoena, Judge, and the state anticipated calling both witnesses all the way up until through the start of trial. And so from the state's perspective, and the issue of whether or not the court abuses discretion in granting a mistrial at the request of the state, goes through sort of a manifest necessity analysis.
All right, and Mr. Holmes, I understand. You probably have some additional legal arguments on that front. My thought is that it's a bit premature yet to go through that. You can flag it, and we'll get into that. Let me start out from the outset. And Mr. Chung, the state is essentially requesting, if not now, at some point, perhaps tomorrow or Friday, that if they're not able to obtain these two subpoenaed witnesses in court, that it should be, they're moving for a mistrial, which means that essentially what we did this week would be canceled, and that we would come back for another trial and start fresh with a new jury from the beginning at another time. And so do you have any position on that at the front end?
Wow. What a decision.
I need to do some research on that, and when that happens, I'll be able to show my position on that issue.
So at this time, you're not objecting to it, you're just deferring?
It sounds like that.
All right, that's not necessarily something that we can postpone indefinitely.
Clearly not. You got a problem.
I'll note, I think the standard that has to be met is a manifest necessity. And, just a few things that give me a bit of a pause, which was despite the witnesses, it anticipated them being waffly. They were subpoenaed and then told they didn't have to come till Tuesday. So we lost a day there. And then when we knew they didn't show up Tuesday morning, I didn't get a ping warrant until the very end of the day. And so we kind of lost another day there. So, I'm trying to work through that. And I'm also trying to work through the manifest necessity of their testimony and whether all the evidence that's already come in really makes their testimony material at this point.
Wow.
I don't know yet. And I haven't made any decision on that yet. And I also think that we wouldn't be looking at a mistrial yet. We'd be looking at a postponement. And whether that's a postponement for 12 hours a day or a week, that's still the bridge to cross before we get to start talking about a mistrial.
Mm.
And Judge, just to clarify my point, I didn't mean to interrupt you. That is the state's position as well.
I understand.
I wanted to make sure that that was provided to the court on the record before the state announced that we were resting our
Okay.
case.
Understood, Mr. Holmes. You preserved the argument. We'll put it that way. Mr. Chuong, anything you want to add? Okay, understood. Mr. Holmes, what else? Anything else?
Oh my goodness.
One other thing, Judge, with respect to the cell phone and the request for that tracking through T-Mobile, it has been brought to my attention through our investigators that the provider has changed to AT&T. So we have prepared a new request for your signature based on that change in subscriber, and then we'll go through the normal steps.
And that's already done and drafted?
Yes.
All right. And can you add we'll add some kind of exigent request to it, or I'll handwrite one. All right. So other than that, though, the state anticipates with those objections reserved, resting when the jury comes back?
That is correct.
Okay. All right. So Mr. Chuong, at that point, yes, sir.
How long are you giving the state to?
Don't know yet. I'm going to see what happens today and if we hear back from AT&T. So, but what we would be doing is they'd be resting, and then the jury would come back in and it'd be your turn to present evidence if you have any that you want to present. And so if you have any witnesses subpoenaed, or if you personally want to testify, this would be your opportunity. And so I have a few questions I'd like to ask you about that. So with the understanding that the jury would probably be coming back in here and it'd be your turn, and I just would be asking if the defense has any evidence to present. I always have to ask this of every single defendant in every criminal case. So do you understand you have a right to testify? And if you want to testify, no one can prevent you from doing so. Do you understand that, Mr. Chuong? Do you also understand no one can make or compel you to testify? That is, if you have a right not to testify if you don't want to. And do you understand that you personally are the one, not your shadow counsel or anyone else, who decides whether you testify? Do you understand if you choose to testify, you'll be cross-examined by the state? And do you need any additional time to think about whether you or want to testify? I'm sorry? All right. And how much time?
The judge just said your shadow counsel can't tell you.
I would need to know if the state's additional witnesses are here to testify before I make.
Well, I'm not going to approve that much time. At this point, the state may never have the opportunity to present those witnesses, and we may move forward without them. And so if they are able to get their witnesses here, it's going to be as rebuttal evidence. And so at this point, based on the evidence as it stands now, it would be your turn to make that
It
decision.
will behoove you to make that decision now, because the judge sounds like he heard enough. You don't need the two parties. You don't need the two witnesses. The visuals are pretty.
That's fine.
besides
So in 10 minutes, I'll come back. And then the only
detective's
question I'll have for you is, do you personally want to testify or not? And regardless of that question, do you anticipate having any other witnesses or any other evidence that you plan to introduce? All right. So we'll be back at 11:10. Be in recess.
Okay, so we'll be back in the court in 3 minutes. 3 minutes.
Yeah,
Go in the back.
Definitely.
3 minutes.
I know those are the things he needed to sign.
3 minutes. Okay, so this is a decision that should not be made lightly, because what happens in the next round? Because the prosecution is about to rest their case. They already said, Your Honor, we want a mistrial because our two material witnesses are not here. Well, the judge said, wait a minute, you might not need that, Playboy. You might not need that. I've heard enough, and I think the jury heard enough. And the lack of those two people being there right now is not so significant because they both gave statements to the police and said Austin attacked them. Austin attacked his father. How is that going to play out, ladies and gentlemen? How is that going to play out for a jury? I don't know. Do you think that these two witnesses and victims are necessary to move forward? Do you think it's necessary to move forward? Do you think you're heard enough? Are you ready to go to the? You're ready to take a vote? Are you ready to take a vote on this case? Well, the judge has signed they want to track the phones. The judge is signing a subpoena to track the phones, and he said exigent circumstances, meaning this needs to happen right away. This judge needs this to happen immediately. So they're going to serve the warrant, the subpoena on the custodian of records for AT&T. And with that, they're going to go into the phone. They're going to go tracking. They're going to find them. They're going to find out where they are. And then when they ping them up north, they're going to call the authorities in that jurisdiction. Hey, go ahead and knock on this hotel room door and drag them out and bring them to. We need to get them back here. We need to get them on a plane. We need to get them back here. You know how this thing going to play out. But this judge is like, nah. You guys might be trying to play the three-car Monty with the court. Now we're gonna send this to the jury. So, but now he has to decide whether or not he's going to testify. I mean, the pressure is on right now. The pressure is on. So Chuong wanted to see if they can find him. A case of hide and go seek. It's going down. It's going down, ladies and gentlemen. It's going down. Let me take you guys back into the courtroom. Let's go. They're not ready yet. I thought they were ready. They are not ready yet. Hold on. Let's see here. What is he doing? Is he wait a minute. Is he texting the family? What is he doing here? He just put something in his pocket. He just slid something in his pocket. Wait a minute. What is he doing? He's doing a young thug, sneaking food in his mouth. I'm sorry, guys. Oh my goodness. Hold on. Let's go back. What is he doing here? He done slip something in his pocket. Oh my goodness. Let's see. We see what you're doing over there, Playboy. We watching you. Where's your shadow counselor at? What is he doing? What is he doing? He's looking around. What is he doing? Are we watching him? We are watching him. He's sneaking. Watch it. Oh, okay. We're gonna watch you, Playboy. We making sure you ain't trying to take one of those cyanide pills. You know what they do when you know you got. Okay. What is this draping the coat over the shoulder? Okay. We watching you. Okay. Watch him now. He put the coat over his shoulder. What is he doing? What is he doing, ladies and gentlemen? What is he doing? Oh, we on his neck right now. Let's see what he's doing in there. You see a lot when they didn't think no one's looking. Oh, okay. Okay, wait a minute. Okay. Okay. Are we watching you now? You turn around. Oh, you spinning around trying to check the room out. Oh no, we checking you out. Yeah. Right. They're gonna throw the phones away. This is right. So you know something? Yo, the family already know. Time to get rid of AT&T phones. You gotta get a Boost Mobile now. You gotta get a burner phone. They on you. They are literally watching everything on their phone, on their AT&T phone. They're about to get rid of that. What are you, boy? What are you looking for? What are you? Wait a minute. Turn around. What? Yo, what is he doing? I'm like, wait, what are you doing? Right. Go check and see what you look at. Yeah. Deputy, go ahead and see what he's doing. See what he's doing. You need to be looking at those files. You need to be looking at your files. You need to be writing your closing argument. Oh my goodness. The fact that he doesn't even trust his lawyer, that's significant. You don't even trust your lawyer to represent you. Okay. 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 What are you doing? What was that? Why did you take your jacket off? I've never taken my jacket off and put it directly on my shoulders. Because if it's going to warm me, it's going to warm me anyway. Oh my goodness. I don't know. Am I looking too deep into what he's doing? Am I looking too deep? Because this is giving me nervous behavior. Okay.
No, I just want to.
You're excited.
No, I'm just making sure I remember.
Exactly. What is in order?
Yeah.
Okay.
Yeah, for some reason I started thinking we were on a lunch break. I just
Judge, what are you doing?
reverted to other things.
Judge, you slipping, Judge. You know this ain't no lunch break. It's only 11:16.
It's not.
Okay, let's go look at
Oh, okay. About what?
Stated, began negotiating a potential I'm just a messenger on that.
I understand.
Potential mid-trial resolution, potential plea. So I was going to ask, or Mr. Trump was going to ask if you could have.
a plea deal. Wait a minute. A plea deal.
I'll get this back on the record. Look, I mean, I think the indication was at the very least we were going to be getting through this and postponing for the day, coming back tomorrow. And so I think the question would be is how does that affect his decision to testify, if at all?
I mean, if you got a plea deal on the table, you might want to let him think about it.
I'm very much interested in doing as much as we can today. All right. Okay. All right. Well, let's put it on the record then. We'll see where we are, and then you can have that time. I'm not opposed to the idea of, usually never opposed to the idea of the parties coming to a mutual agreement.
Okay.
All right, let's go back on the record. It's been about 15 minutes, Mr. Chuong. And as I indicated, the question that I have to put to you is whether you personally want to testify or not when it's your turn and it's your opportunity to present evidence. You would like to testify. All right.
What? Oh,
Okay. And so in terms of the format of how that would work,
yeah.
I
How's that gonna
believe
work? Are you gonna ask the question and jump off the stand and then? Wait a minute. What the heck?
that this would
This guy.
be best, since Mr. Shaw is just shadow counsel, that this would take a narrative form, that Mr. Chuong would take the witness stand and he could start explaining his testimony and what he thinks is relevant. And the state could then be making objections as the narrative
Oh my
proceeds.
God, this
And
this
Mr.
is gonna
Chuong,
be
whenever
bad.
there's an objection made, it's very important that you stop talking immediately. We work through the objection, and then I'll rule, and then you can either continue or modify what you were saying. I don't think so, because I think that crosses the line into then showing that he is representing you and making strategical choices about what to ask you and what not to ask you.
Oh wow.
Is there anything that you think you wouldn't be able to cover if Mr. Shaw is asking the questions versus you just providing a narrative?
Nah. Oh my goodness. This is weird. Judge, this is gonna be an appealable case, Judge. Talking to the mic, sir.
You can have another minute or two if you need to talk to him, but because of the posture we're in, I think it's a free flowing narrative. And when an attorney asks you questions, that then brings them into the calculation that I don't think we're supposed to have here in a pro se situation.
Right, he's pro se. You
All right.
have already created the narrative that you're representing yourself. Take the plea. Take the plea. Take the 30 years. Take the 30 years. Because what's going to, I'm going to tell you, ladies and gentlemen, what's going to happen. He's going to get on the stand and he's going to do so horribly that the prosecution will say, nah, we don't want to do a plea deal. Nah, let's just send this to the jury. Don't fall for the okadoke. That's the okadoke. That's the okadoke. Don't do it. You're going to testify.
Yeah, I'm just saying, man, that's my last best option. Yeah.
Man, don't get on the stand testifying on your own behalf. No, because they're gonna see how bad you do. You're gonna do so bad. They said, "What plea? That 30 years not. You just accept the 50 years. How about that?"
Who's they? These things? Yeah. No kidding.
Also, this is not Judge Judy. These are not actors. These are real people. The decision in this case will affect your life.
Yes, sir.
Would I testify today or tomorrow?
As I mentioned, it would be pretty much, we'd start now. The jury would come in, state would rest, and then I'd be looking at you to see if you have any evidence to present.
Oh, decisions. You want to be grown. Now you grown. Step up.
I assumed you would request.
Talk up, man. You want to be pro se representing.
Yeah, Mr.
Come on.
Well, Mr. Chuong, again, if you need a little extra time, I'm willing to give that to you. But again, the ability to stay on track and the anticipation of delays is something I've always got to keep in mind. And I guess to me, I'm not really seeing the major functional difference between you being able to provide your account versus having questions asked of you. I mean, we could always, if we need to, before you give up or finish your account, I'd allow you the chance to confer with Mr. Shaw to see if there's anything else you think you need to cover. But again, I'm thinking that Q&A format is just not something that's appropriate when you're in a purely pro se posture. Okay. So, how much time do you think you need to gather your thoughts here?
10 years.
That's fine. We will tell them that we'll break now. We'll go ahead and bring them in, have the state rest. Then we'll break and we'll have them come back early. We'll have them come back at like 12:30. And we'll proceed with your testimony if you have any. And as I understand it now, the parties are also broaching a resolution potentially?
Yes, Judge, and considering the court is gonna bring the jury in for us to rest, and then they're gonna go on lunch break, I would like to take this moment to acknowledge that that negotiation, will expire before if the defendant chooses to take the stand, it would expire before that. So on the lunch break,
All right.
we'll be asking that all of that be taken into consideration.
Okay, well, we'll do this then. I'll make the lunch break a little longer. We'll have it at say 1 o'clock, and you can tell me, I imagine very early on, there may be an indication of whether things have broken down or not. And I anticipate maybe the parties will be sticking around in the courtroom. So you can just give me those updates as they come. And if you come to a resolution 30 minutes from now, let's just go ahead and come back and talk through that. But I'll go ahead and bring in the jury and tell them to come back at 1 o'clock. All
So
right?
guys,
We can
yeah,
bring in
you
the
have
jury.
to- this is a real question. Can I be in the courtroom at 1 o'clock? Put a 1 in the chat if you want me inside the courtroom at 1 o'clock. Put a 1 in the chat if you want me inside the courtroom at 1 o'clock. When I got to court yesterday, the witness was off the stand. Y'all like this view? So I can leave the stream up, but I can go in the courtroom and I can witness him from the seat, sit right behind him and watch him testify. I think I should get to the courtroom. I'm gonna keep it live and I'm gonna go to the courthouse. I'm gonna do this for my people. I'm gonna do this for my people. And you're gonna see me do the head bop when I walk in that courtroom. Wait a minute. Faith told me to stay. Throw the tomatoes at Faith. I'm ready to go.
Thank you, Deputy Scott. All right. Welcome back, members of the jury. State may call its next witness.
Your Honor, the state would rest subject to rebuttal.
All right. So, members of the jury, at this time, the state has indicated that, subject to any rebuttal evidence, that they've presented their case in chief. And so, what that means is we would then turn over to see if the defense would like to introduce any evidence. The defense has no burden whatsoever, but they have the opportunity to present evidence if they want to. Before that can happen, we still have a number of things that we have to do outside of your presence. So we're going to have to take another break because it's close enough to lunch. I figured we would just merge those two together and have a longer lunch break.
Wait, is it raining?
And so
Is it
we
raining?
are still working. We are still on track.
I don't give a damn.
And
I need to be in this
I'll ask
courtroom.
you all to be back, ready to go at
I
1
need to be
o'clock
in this
this afternoon.
courtroom.
Okay. Any questions before we break from anyone? Thank you so much.
Thank you. Listen, I'm going to the court. I'm going to the court. I'm going to the court. When I get in there, I'm going to salute. I'm going to walk inside for my people. Okay, so who's going to take over the comment section as I'm in the courtroom? Who's going to be the moderator to make sure people ain't acting foolish? I need someone to say, I'm going to be the moderator, control this room, because I gotta bounce.
All right, we'll be in recess until 1 o'clock or until I receive any other kind of notification from either party. And so Deputy Scott, I don't know, at least for the next 30 minutes, perhaps. I don't know if Mr. Chung would prefer to stay out here, if that's more conducive.
Mr. Chan, I'm coming. I'm coming. You're gonna see the black guy in the courtroom. You're gonna say, who's this black guy? It's me.
Okay, I think actually he wants to go in the back. So
Okay, ladies and gentlemen, I gotta go. I'm about 40 minutes away from the courthouse. I'm gonna get in my Batmobile. I got the van, but I got the Batmobile. I'm gonna have to do a little speeding, but I'll be there. I'll be there. Be more. You are now designated moderator. I'm out of here.
All right. Can we bring on Mr. Chuong? Okay, but nothing's live at the moment. Okay. Is he in the restroom or something, or what's going on?
He said second. So he's ready on bench.
All right. It's been a second. Let's keep it going. All right, let's go back on the record. We are back after our extended lunch break. It's now 1 o'clock. And where we had left was the question to Mr. Chuong. He had said he was personally willing to desiring to testify, and the state had rested. So the plan would be to bring the jury back in and then turn it over to Mr. Chuong for any evidence he has to present. Is there any reason, beginning with the state, that we should not proceed?
I don't know where they stood. Mr. Shaw stepped over. I don't know, so.
No reason from the state. All right, Mr. Chuong.
Yes, I agree to the offer of conflict.
All right, we need to outline the terms and make sure we're all clear on that. And if that's the way you want to go, it makes no difference to me. But we need to make sure we understand everything. We can go through that. We can enter the plea, and then we'll defer sentencing and excuse the jury, and we can come back and handle that. All right. So first, let's make it clear what it is you believe that you're agreeing to. Okay. So let me start, Ms. Willingham, what you have to add.
Offer for the defendant to enter a plea to the remaining charges. I'm sorry. The state would move to null cross contingent upon the defendant entering a plea. Counts 1 and 2 of the indictment. The defendant has already entered a plea as to count 4 and 6. He would then be entering a plea to the remainder, which would be count 3, 5, 7, 8, 9, and 10.
Oh,
The state would be asking, as the defendant has stated, it would be non-negotiated, and the state would be asking for the maximum sentence on those charges, which by our calculation would be 81 years. And that includes the mergers of the ag batteries, or the ag assault into the ag batteries for counts 4 and 6, count 7 and 8. And that is it.
all right. Mr. Chuong, is that your Okay. Is that your understanding of the state's offer, Mr. Chuong? And so, Ms. Willingham, the state would be, I guess by null processing, there's not really reduction, but the state is willing to also present this offer as in a non-negotiated posture. All right, and this would be a guilty plea, Mr. Chuong, with to counts 3, 5, 7, 8, 9, and 10. Is that your understanding? Just everything that, other than the first two, and everything that you hadn't already pled guilty to. All right, is there anything else that you want to add before moving forward then? And we would go through all the rights, and we'd go over this again during the colloquy as well, just to make sure. But if there's anything else you want to discuss before, I just want to make sure if there are any other lingering concerns that you have. First offender is something that you can request. It's not something that you're guaranteed. So that would be part of the non-negotiated aspect of it, first offender. And then I think we just need to address this, because I can see it coming up, and we shouldn't waste any more time on it if it's going to be a sticking point. But it also sounds like your shadow counsel is explaining to you something called an Alford plea, where you're not admitting guilt per se, but you're just accepting the consequences because you think the evidence is strong. And that causes me some pause, especially on a case like this where we're mid-trial. I've heard a lot of the evidence and based on the nature of the charges. But I'd be willing to hear first of all, is that what you would be seeking to enter your plea? Saying that you did not commit the crimes, but that you're wanting to be punished for them and accept the punishment? Okay, Ms. Willingham, what is the state's position on an Alford plea? All right, and that objection would be the null process of counts 1 and 2 would be conditioned on that. All right, so just to make it clear, Mr. Chuong, if you're wanting to go forward with this, the only way it's going to be possible is if you're actually admitting guilt to the charges you're pleading guilty to. There is sometimes an option in other cases, a way around that, but apparently not here. All right, does that make sense? Okay. All right, well then you can have a seat and make sure that you're talking clearly into the microphone. And Ms. Willingham, I'd ask that you go through the colloquy. And I think for the purposes of the factual basis, you can just rely on the record that's been presented. And I think the defense would likely be stipulating to this factual basis.
Yeah, but hold on, my feet. Would you like me to come up as I usually? If I wait, if no, the other three. I'm there finished.
All right, Ms. Willingham, if you could swear in Mr. Chuong and proceed.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Can I get 5 minutes to discuss?
At this point, Mr. Chuong, I mean, I've given you a lot of time to talk these things over. We've had a long lunch break. It's an important decision, but it's, first of all, when you said your counsel, you don't have counsel. That's just you. And so I'm not really clear what could still be left to discuss at this point.
It's just. The sentencing will make you. Yes, I would like.
Okay, so again, Ms. Willingham has a lot of things she needs to go over with you, and you got to listen to them very, very carefully. And if you have any questions about them, you can let me know. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name, your age, and your date of birth.
Austin Chuong, 23, April 2000.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Sophomore year in college.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Can you repeat that? I'm sorry.
Have you had the opportunity to review the document that charges you in this case, the indictment?
Oh, yes, yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
It is my understanding you are entering a negotiated plea. Upon the entering of this plea, the state would be null processing count 1, murder, and count 2, felony murder. You've already entered a plea as to count 3, aggravated assault with a deadly weapon, and count 6, aggravated battery. The remainder of the indictment counts 4, aggravated assault. Count 5, aggravated assault with a deadly weapon. Count 3, aggravated assault with a deadly weapon. Count 7, aggravated assault with a deadly weapon. Count 8, aggravated battery. Count 9, hindering a person from making an emergency telephone call. And count 10, possession of a knife during the commission of a felony is what you would be entering a plea to today. Is that your understanding?
Yes.
The maximum sentence for all the charges you will be entering a plea to include the ones you've already pled to, would be 86 years. Is that your understanding?
Can you repeat that?
The maximum possible sentence you could receive for all the charges that you are entering a plea to include counts 4 and 6, which you've already pled to, is a total of 86 years. Is that your understanding?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
Do you understand that you are entering a non-negotiated plea and the court may sentence you to any sentence that is authorized by law?
Yes.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. The special conditions have not yet been determined, but if you are given special conditions, you would have to abide by those as well. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied? I'm sorry. Do you have any more questions before we go on?
No.
Let me pause you there, Ms. Willingham, and let's make it clear what your belief is on which counts merge so that I can be
Yes, Judge.
very clear on what the maximum is. So count 3 alleges a aggravated assault upon Mr. Andrew Chuong.
Yes,
And
Judge.
so that stands alone if 1 and 2 are then dismissed. Count 4 is the striking of the baseball back to Eric Chuong, ag assault. I believe that looks like it would merge into count 6.
Yes,
right?
Judge.
Okay. And then count 5 is the ag assault cutting Eric Chuong. And
That count stands alone.
that count is its own independent allegation. Count 6 is the battery Eric Chuong baseball bat. Count 7 is the one that would merge into count 8.
Correct.
All right. And then hindering a 911 is just the 12 months is the misdemeanor.
Correct.
And that's how we reach. So 20 years is on 3, 5, 6, and 8. Is that right?
Yes.
And then the remaining 6 is from 12 months on count 9 to 5 years on count 10.
Yes.
All right. Do we also have the indictment that we had joined issue on earlier today? I think the court reporter might have a copy.
You are dismissed. You already pled guilty. You're not.
If you could present this, Ms. Willingham, to Mr. Chuong for his
Yes.
signature and indicate which counts
Yes, you
we'd be
can.
going forward on.
Yes.
Just do it in the second column for an additional signature.
That one 20 years. This one you can't. This one 20 years. This one clean. Oh. No. No, that is not. Everything except count 1 and 2. You're pleading guilty to everything except count 1 and 2. We're just talking about what you can be sentenced to. And when it comes to sentencing, those counts that merge, you cannot be sentenced to both of them. You can only be sentenced to, you can't be sentenced to assaults. The ag assault on Eric for hitting him with a baseball bat merges with the ag battery, so you can't be sentenced to this one. You have to be sentenced to this one. You're pleading guilty to everything, but you could only be sentenced to this one, not this one. Okay, and then with this ag assault, that's on Eric. There's no ag battery, so that's the only that stands separately. And then this ag assault is on Jenny Fang. Be sentenced to this one. It merges with this one. So 20 years for this one, 20 years for this one, 20 years for this one, 20 years for this one. So that all together is 80. And then 6 years for these two. Well, 6 years for this one. 6 years for this one. There's no max on this one. That's how you're getting 86 years. Okay?
That's how she's getting the maximum. of
That's the
86.
max, 86 years.
It's not scary.
All right?
Yeah. Mr. Chuong, I presented you with the indictment that you assigned earlier in this trial, joining the issue, and when you pleaded guilty to 2 of the counts. And so if you can take a look at that, we would also require your signature to indicate that you're now pleading to the remainder of the counts. Do you see that indictment in front of you?
Yes.
All right. And so could you sign that at this time if we're moving forward?
You're signing here.
All right. Ms. Willingham, you can pick up where you left off.
Understanding all of your rights, I'm sorry, have you understood everything I've asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
And Judge, before I get into my next question, it is my understanding that the defendant has waived his right to appeal as to the previous counts that he entered a plea to already.
Mhm.
The state would also be asking that that apply to the remainder of this indictment.
That's right.
So
So,
I just wanted to clarify that.
Mr. Chung, do you understand that once we finish tendering your guilty plea and I accept it, that you would be waiving your right to withdraw that plea simply because we have not sentenced you yet? After sentencing, you would still retain limited appellate rights, which Ms. Willingham will explain to you in terms of the timing of how to withdraw a guilty plea. But there's also an avenue where someone can withdraw a plea before sentencing. And what I'm asking you is if you're going to waive that right so that I can send the jury home.
Case, he can excuse this jury. If you don't waive that right, then he's gonna have to hold this jury because you might withdraw, you might try to withdraw this plea within this term of court, and then you'd have to continue with the trial.
Yes.
All right. And Ms. Willingham, you can continue.
Yes, Judge. If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses, and you will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
Do you understand that you are not allowed to possess firearms during the course of your probation if you are given probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
And, Your Honor, I recognize we have put quite a bit of
All
the
right.
facts on the record.
Let's do this for a factual basis. Would the state be alleging and incorporating all the evidence presented during this week?
Yes, Your Honor.
All right. And as well as the averments in the indictment.
Yes, Your Honor.
And Mr. Chung, are you stipulating for the purposes of this plea that the state has introduced enough facts to support the charges you're pleading guilty to?
Yes.
During the trial.
All right. Anything else, Ms. Willingham?
Nothing further from the state.
All right. And I don't know if this was made explicitly clear as part of the plea colloquy, but generally, the state's recommendation in this case, along with maybe other terms and conditions, is the maximum possible sentence of 86 years.
Yes, Judge, and I can get into that if the court would like. I didn't know if you wanted me to reserve that for the sentencing hearing when we have it.
Well, just so that he's aware of what the
Yes.
state's going to be recommending. When
Yes,
you say the
Judge.
particulars, they're all going to run consecutive and you're asking for the max.
Yes, Judge, should this case, the state would be asking for each count 3 through 10 to run consecutively, and we would be asking for the max, with the exception, obviously, of the counts that we've previously discussed merged.
All right. But none of these counts, though, have a mandatory minimum to your knowledge.
No,
So there's no required court has to accept.
correct.
All right. Okay, Mr. Chung, I'm going to turn it over to you to ask you a few questions to emphasize some things I need to make sure I know, which is, do you understand the nature of the charges that the state's going forward on today that you'd be entering a plea to?
Yes.
And do you still wish to waive all the rights that the state went through and go forward with this change of plea? Do you understand the court's not bound by the recommendation the state makes, and I'm not bound by the recommendation you make either, because you didn't present me with a joint recommendation. So essentially, I'm going to try and look at the facts and everything that's presented to me and make a determination that I think is the appropriate sentence.
Yes.
And you're pleading guilty today because you agree that there are enough facts that support the charges you're pleading guilty to? And let me just ask, since even though we're in this unusual posture, Mr. Shaw, you've been sitting as shadow counsel alongside Mr. Chuong this entire time. Do you have any concerns over his competency or his understanding, or whether this is a voluntary plea?
I believe he's competent, and I believe this is a voluntary plea, Judge.
All right, and I believe Mr. Chuong has also been asked this following in the same himself. All right, Mr. Chuong, is there anything else that you think you'd like me to know, not on sentencing, but before I accept this plea? Or do you have any other questions for me?
No, Your Honor.
All right, well, in that case, I do find there's a sufficient factual basis for these charges, and I find your plea to be knowingly, voluntarily, and intelligently entered, and I'll accept your plea. We are going to defer sentencing, and now that the plea has been accepted, we'll also note on the final disposition the state's dismissal of counts 1 and 2. All right, if there's nothing else, then I would propose we bring back the jury.
Judge, may we ask before the jury comes out if we will have an opportunity to speak? I don't know if the state
Yeah.
is also interested in that.
Yes.
Okay.
I always do that.
Want to check.
Is there anything else? Okay. For this before, we post the file, so she can scan it.
I mean,
Yeah, I think that'd be the best. All right, thank you, Deputy Scott. Please be seated, everyone. Members of the jury, thank you for, as always, your continued patience and for being back ready and on time. Have something of an announcement for you all, which is, as I promised, while you're usually outside of the courtroom, we're trying to keep working in here. And it was brought to my attention that the parties had reached a resolution of this case. And while you were at the lunch break, we entered that resolution. And the case at this point is now over when it comes to your involvement. And so once I excuse you, you can step on back and gather your belongings. And at that point, you're free from your service. And especially with the thanks to the court for all the time and the effort that you put into this. And you'd be released from any obligation you have to talk about the case or share whatever you want about it. And I will say that once I let you go, I'm going to dash back there because I usually try to thank each of you as well. And I know that the parties a lot of times want the attorneys, that is, want the opportunity to be able to talk with you and get your thoughts about what you thought of the evidence so that they can help them and so they can learn how to present the evidence. And also they just want to hear your reaction to it. So if you're willing to stick around and share those thoughts, we'd love to hear them. And I'll also be back there to answer any questions you might have as well. So if there's nothing else, and we'll also, if you need it, we're going to be preparing excuse letters for you now, documenting this week that you were, that you were here with us the Monday through the Wednesday. I can't get you out of work tomorrow, I'm afraid. But it is with the thanks of the court that you're excused from your service. Thank you so much. Oh, I think there is a question. Ma'am, if you could identify your juror number for us one more time. Okay.
Did we find out what happened?
I can come talk to you in the back when we're done and off the record. All right. Thank you so much.
All right, the judge.
All right, we'll be in, well, let me ask this while we're still on the record. Mr. Chuong, is there any reason why we should not proceed to sentencing at some point this afternoon? Is there anything you're waiting on in terms of additional time or evidence or witnesses that you would want to present for sentencing?
That I did want to correct one thing, count 10, possession of a knife during the commission. There is a mandatory minimum of 5 years on that, but as your honor knows.
It can be probated, suspended. That's right. Well, I imagine I would go talk to the jurors and they may have some questions and want to debrief, and that process takes about 20 to 30 minutes. And the attorneys may have some questions as well. I'll let Mr. Shaw go back there if the jury wants to talk to them, and him and Ms. Willingham. And so essentially what I'm asking is, when we get back from that 30 to 40 minutes from now, maybe sooner, if you would be ready at that point to go forward with sentencing. In sentencing, we've already gone over the plea is entered. So sentencing is just going to focus on arguments you have, evidence you have, if you want to present some, in aggravation or mitigation. Usually the state's going to be the one trying to say that the evidence is aggravating. If you think there's mitigating evidence suggesting that the sentence should be lower, sentencing is where you would make those arguments and where you would present evidence, if you have some, of why the sentence should be lower. And that's not evidence saying you didn't do it. At this point, that is an established fact based on your plea. The evidence would have to be relevant to showing your frame of mind at the time, why perhaps it wasn't a premeditated or calculated crime, why you shouldn't be punished as harshly as somebody else should be punished. Does that make sense? And so do you feel prepared to be able to make those arguments this afternoon? And if not, I'm open to the idea of bringing everyone back Friday and handling it Friday. Today's Wednesday. How about we do this? You can go back and talk to Mr. Shaw for a little bit while I talk to the jury, and I'll send word when it sounds like they do want to talk to you, Mr. Shaw. So that'll probably be maybe 5-10 minutes from now. I'll send word that they can come find you. And then Mr. Chuong, I'll check back in with you in a little bit. Okay. All right. We'll be in recess for the moment.
You have until Friday to figure that.
I saw you.
I always.
Yes. You look good right now. Well, that's. Oh, yeah, they definitely was great. Y'all doing all right? Maybe it's.
Should have fired her. Just didn't give each other a handshake. This is why sure.
I think it's. I'm gonna. That was.
Oh, yeah. She was there. Interesting. Today. Oh, then we shouldn't be doing this. Huh? You shouldn't be doing this. I don't want to be stuck here at 10:30. Yeah. Well, the judge asked that you can do it. Does he want to do it? You are better, I think you should ask them why. Are you coming from? Yeah. Judge off. And he's like, what can I sound like? You shouldn't have fired us. I tried to explain to him what sentencing is.
I only want, yeah. I only want to go.
Kids it happens, right? Right, exactly. But it's half now. What because they want to like, or like me like that.
3 years ago?
Life is 35 years. But murder is like.
Yes.
So. On maximum is 86. Without the release. Oh, good for you. There's no bit. There's no bit. That no. No, I'm sorry. You were to ask. You ready for us? I think he's already done 4 years. I don't think they know. I'm not sure. I'm not seeing any cases, especially in federal. You just want the witnesses. Yeah. Yeah. He's a suspect. Right, fences. Check out the comments. I might support it. Everything's supposed to happen. There's not anything. Oh my God. There's another.
She didn't know how to think. I'm not even.
We're gonna. We should try to get it.
I'll be honest with you, that's actually what I was wondering. That's literally my first thought.
Why should, you should not. You shouldn't.
That was what I thought you were trying to.
That was a joke.
I mean, no, I knew it was a joke. I knew it was a joke, but it was actually my thought.
No. Every time I try to be again.
Is your mic off? Because the YouTubers are listening to the call.
All of these lights are off.
Yes. We learned that.
Okay.
Bob texted me, Bob, we can hear you.
Yeah, all all of these mics on, I don't know
Yeah.
if,
You
oh,
were in
if
the
judges
meeting,
is on.
Weren't you
I
in the
was-
meeting that we had for
No,
Jeff?
the witness stand. Oh,
A few
I
months
think,
ago.
oh, the witness.
Well, that was a different
I
investigator.
had this case since it happened.
That was a different investigator. It was two
I'm
other
not an
investigators.
investigator.
Oh,
I'm a victim advocate.
I got you.
So I,
Was
but
it?
I'm not,
It was a-
I'm not investigating.
Was
I'm a
it two
victim
investigators
advocate.
that we had in that meeting? The round table?
That was, yes, that was Investigator Walker. He testified. He's now back with APD.
He
He's the one
tested?
that-
Oh, that's right, that's
He
right.
testified. He was my investigator back in December.
Yeah.
And, his supervisor, AC,
Yeah.
followed the.
Yeah, it's insane. It's insane. And. Yeah. Yeah. When it comes back, yeah, if it comes back, you realize. So. Yeah, that's the one. Yeah, you make that. Yeah.
These are the 86. These are the 86. These are the 40 years. This is exactly. I don't think it's all, I think it's. You gotta look at this all the time. That's fine. So 8, 85. 23. People with the jurors, we know how to work. That's why I said that was.
I'm gonna go back. They're gonna send this on Friday. Yeah. I think Judge is gonna look.
Are y'all leaving?
Yes,
You're a juror, right?
and I'm not
Oh, okay. Okay.
They thinking that, yeah, we're not jury. We work here. Let's go. I got the.
That's what she said.
They gonna bring him back out?
Yeah. Okay. Go ahead. He says it before the devil, you know. Like, yeah, he says it's man, he like, yeah, he will. He will. All the blood, 3 DNAs on this single guy. 3, so how did that happen? What was this? Yeah. Located between the right about the pressure conference machine, like the body yard door. Yeah, but in between, okay. And you're shooting by the table. Are they gonna rescind those warrants, those mature witness warrants? Cause it's still out there. What is that law? Maybe a candidate. Don't wait to get extradited from Canada. She's more upset than they are. We're more upset. I said that. Yeah. Yeah. Was it that umbrella? Yes. Oh, yeah. Listen, my neighborhood. I don't think so. They had police reports coming up about that house. So. Maybe four of them. What do you four of them? No. Is he? Okay. That is the law. Yeah, very good. Very good. Yeah. Why did they want President Governor? Oh, this one, yeah. So they get the. I was tweeting 17 minutes. So they don't come. Quiet, whatever. It is quiet, that's why this case. It gives me big crimes out. Yeah. Yeah. This story is not old. Somebody points to the story. Yeah. Well, yeah. Good. I don't bet they're gonna find one. Yeah, the house will be in a Zillow tomorrow. Yeah. Still keep. Ask him about the car. Man, that was crazy. That was crazy. Yes, that was crazy. That was the craziest thing I had. Did you know it's a 911 call? She was called in. You didn't hear the attack on the dad. You heard the attack on her. You didn't hear the attack on the dad, but you heard the attack on her. I didn't know the fish. No, whatever. Oh no, this might be a documentary. If I want to go to China and interview them. I don't know why I tuned into this report.
Hey, go ask him. Ask him what he want to do. He want to do it today, or he want to do it Friday. He told you going Friday? Friday, wrap it up.
They don't do PSIs. You said it's they don't do that. You familiar? You live in, it's the Bronx. He don't put down. Wait, for the case. Where's the break? I know that the king illegal. That ain't illegal. Well, there's great. Not great though. I come to the nation for you, so. You know, in his case, there's that cool. So, yes. All right, Brian. All right. All right. Yes. It's gonna be simple. What? My next one, first thing. How much time for that? 20 to 25. Uh-huh. Yeah. Innocent people don't take food like that. Innocent people don't take food like that. They do? Maybe 16? People think they'll do what they want on the.
Same thing, I stopped that thing already sent out that already answered students. And then we were in there too. Already answered it. He wanted to know. Can you confirm that you already did? See, and I made sure y'all were all in there. It's a big question. I answered it. But he'll leave us something.
But you see, she just said something today. She got the info and stuff.
The 15.
What's today? Day 6.
Have the warrants removed. It's like, we don't know that. Sounds like we just want to use it. We're about to kick them out. Don't worry. We're gonna get our people out.
Who's on now? One person.
I don't know. He said, make sure you get this warrants. Take it on. Move ASAP. We're on that. Already answered.
Scott needed her sister, but all I do is email the lady and tell her to call the warrants. She come on the 9th floor.
You know. I'm not a joke at that. Never know we're gonna do it Friday, we can pull up.
Yeah, how much to say?
It was 50-50. 50-50? Oh, my God. 50-50? Yeah, it seemed like the room was about 50-50. What you think?
About 30, but it don't matter, it wasn't 100, that's all that matters.
Yeah, 100.
It was this time, so
Oh.
I think we did what.
What was the biggest thing that you were missing? Biggest thing, you know, I can.
No, we were talking about. And then, yeah, they got their own. Yeah. Everybody said that, everybody in there said that. That's why they think they were all in. That's what they said.
I said that. Walking in, you know, like nobody said, hey, dad, over there. Like nobody said, she's like, oh, she's shocked. Like, oh, that's just my dad. Yeah, like, yeah.
Like, he was like, not even a matter of thought.
Yeah, that's all kind of stuff. Something. They, maybe they guess like.
Maybe that's what it's like. Yeah, yeah, that's right, that's right, that's right. Yeah, that's right.
I'm still big.
We know.
Oh, yeah, we. Oh, come on now. They're still Georgia? They're still Georgia? Oh, God. It's like my version. You just don't get up with the hell. Oh, listen, there's a book here. This is Dr. Bishop. Yeah, because they, listen, it may be a case within a case.
I'll wait for it.
Oh, you can wait.
Yeah, go. Better give him a little short stuff out here.
The jurors back? They still back.
She's still on the wall. I wish it would talk.
They want to go with the alcohol.
Yeah, they do. And I'll-
They know. Even for people who say they understand. Yes. Sit in there.
You been here.
All right, it's now just a few minutes after 9 o'clock, I was waiting for two other committee members, Senator Hatchett and our minority leader, Gloria Butler. I think they're both en route, but we do have a quorum. So we'll call our meeting to order. This is the Senate Special Committee on Investigations. We have issued a subpoena on February 28th, and that was issued to Miss Ashley Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We also subpoenaed her to testify before the committee this morning, as is permitted by our rules. Ms. Merchant responded to the subpoena and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any committee member to review at your pleasure. Just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The minority whip took some time last night, and I think he may have been the first person to really review all of the records and spend a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all of those documents will remain confidential. I remind the committee members in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony. But I will ask you, Ms. Merchant, to let us know if anything in your opinion is confidential that you would not like for us to publicly disclose for whatever reason. And then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly. But just to sort of set the ground rules here, I will conduct the interview with you. You will be sworn under oath. Ms. Brenda Elwell is our court reporter. She will be making a transcript of all the proceedings, and that will be publicly disclosed for the press if you want to go back and double check and see exactly what was said. That will take a couple of weeks to prepare that transcript, but this meeting is also being live streamed, so it should be easily accessible to the public and anybody interested in this. I'll begin. Ms. Merchant, you are here under a subpoena to testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, I do. So, well, if you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's saying anything, let me know. The way our procedures work is that I will be asking the questions and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, et cetera.
Definitely. My name is Ashley Merchant. ASHLEIT. Last name Merchant, MER.
You're going to need to pull that mic
I'm
a
sorry.
little closer to
Thank
you.
you.
So
And is it okay? I have a notepad just in case
You're
I get
absolutely
two
free.
questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, et cetera. But since you are an attorney, apparently you're very comfortable responding. Okay,
Yes.
Didn't mean to cut you off. Let's
That's
just
okay.
make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004. So I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights. And then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the merchant law firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes. Yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive award about my work defending the Constitution.
So you are the current president of the Criminal Defense Lawyers Group?
Yes, yes. And it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals. Appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies, so anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, around, I think it was late August, to represent him. He lives out of state, does not live in Georgia. But so I've been his defense attorney since the time of indictment.
All right. So late August or September of 2023.
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23. And then I negotiated bond for him, walked through the turn-in process and began negotiations with the prosecutors.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers. There's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process.
Yes.
And those are the documents that are deemed to be false there.
Yes. That's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump.
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman.
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there were some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. as far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but
Okay.
not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but
Right.
everybody else may not.
Yeah, definitely.
Yeah.
So, so we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents, the documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated?
Yes, yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that, or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state. And nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all, or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order
Sure.
protecting. So I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time, it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury. And I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But, from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury. And so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
Yeah, I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did. Yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, the special purpose grand jury process, to bring in testimony and bring in, witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's this transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021. To work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no.
All right, ladies and gentlemen.
I've heard him go by counsel, things like that. But I don't really think
Hold on.
counsel would be an appropriate term.
Hey, I'm back, ladies and gentlemen.
I did not
I
know this before,
am
but I
inside
studied
the
structure of
courthouse
the
right
independent
now.
counsel in the federal system. They're
Can you
actually a
guys
separate
hear me?
office.
Put a 1 in the
The
chat if you can hear me. I
appropriations and
am
all
in the
separate offices. They are
courthouse.
kept separate from
Put a 1 in the
district
chat. Put a
attorney's
1
office.
in the chat. Put a
So
1 in the
that would
chat.
be where you get the independent counsel term from, or independent prosecutor.
Let me give you
He
guys an
goes by
update.
special, usually.
Let
So
me give
special
you
prosecutor or
guys
special,
a
special
update.
counsel.
I am back,
And
ladies and
I think
gentlemen.
that's
I am
because he's
back.
not independent.
Okay. All right. I'm still in the courthouse.
In the state of Georgia, I don't know the
I want to
scope
give
of
you
your
guys an
case. I'm
update.
not familiar with DAs
So,
doing
Mr.
this
Chuong
No, and so I
Austin
do practice
Chuong,
throughout the state. And
has
I've practiced in
elected
almost
to
every county in
have
the state at
his
some point in my career.
sentencing on
And it
Friday.
is very rare.
So
I've
this
had
is why we were waiting
instances where
around. The
there
judge
is
has left the
special
building.
counsel,
The judge is gone.
but those were very
The
limited, and
jurors
I can
are still
tell
in
you
the
about those,
building.
and then I can also
I was
tell
able
you,
to
what I
interview
did
the
to investigate
lawyer
that, 'cause I had the
representing
same
Mr.
question.
Chung.
So
And I was
first-
Just so
also
you'll
able
know
to gauge
why we're
what the
asking.
jurors had,
The scope of this
what they were
committee
wrestling
is
with. So I got some
we've
good
heard a lot of the
information, ladies and
allegations, and
gentlemen.
you, as a matter
Let's
of
see
fact,
here.
made most of them, or made
Right.
some of these public, and there's of course a public
Oh, you see the people talking in the background.
rage or uproar or
Oh my
concerns
goodness.
about some of the alleged
Oh my goodness.
crimes
I didn't cut up.
that
You thought I was going to cut up. You thought I was going to act a fool.
within the
Man, 86 years.
in the system kind of
He's
what's
pled to
appropriate conduct
86 years.
and also financial.
Now, the judge
crimes.
on Friday
And
can
we're tasked
give
with
him
investigating
less than
and
86
finding the
years,
true facts,
but the
and
86
not
years
just
is the
taking
maximum
press
that he is
face value,
facing.
and that's why we're asking
Why would the
you
judge give him less than
documents,
86
et cetera,
years?
so we can
There could be
independently
mitigating
verify the
circumstances
various allegations
where the judge may
made.
decide
But we're also
that,
specifically tasked with
there's
if
reason
necessary,
that he should get a
amending
lesser
existing
sentence.
Statutes.
This
or
is a
creating
crazy
new
case.
statutes to build
So what I've
guardrails or
learned
whatever to
from the
essentially
jurors,
restore the public
some
faith
of them believe
our
they
criminal
didn't,
justice
they
system,
weren't 100%
in
for him
its
being guilty.
impartiality
There
and
was
its
a
fairness.
50-50,
I have looked at some of the existing
as to his
statutes,
guilt.
but it's very
and that's significant.
sketchy.
Does anyone know why
what
the
is the
jurors
real
were
authority?
leaning
we wonder
towards
if we need
the
statutory
50-50?
authority for
What piece of
limitations.
evidence do you think they
So I'm going to
seen
explore with you a
that
little bit
would
what the
give
authority
them,
is for a special grand
this-
jury
I'm not 100% sure
conducting a criminal
idea.
investigation, and also the use of a special assistant district attorney.
Well, I'm going to tell you what it is. The body cam video.
The context. You have done that.
The body
research, so
cam
help
video
walk us through this
rested
just a
heavy
little
with a
bit.
lot of people.
Is there a statutory process
reaction
that gives authority to
as
utilize
to
a special grand jury to
What people
advise
saw
the
in that
DA
body
or to
cam video
essentially accumulate
was
evidence for a
disturbing.
DA, to determine
The
whether or
fact
not
that when
Right.
you look at the
So-
body
so
cam video,
the first,
you see the
so the first
detective
question was
talking
about
to both
whether
the
this
mother
happens
and
throughout state
the
or not.
brother for a few
I
minutes.
did do open records.
It
to
was
every single
only
district attorney
until
in the
she
entire state of
turns the
Georgia to
corner
find out, because I
and
wanted
see
to
that
know.
Mr.
I
Andrew
knew based on
Chung
my practice
is
that it was
laying in a
very
pool
rare
of blood.
process, but I wanted
And
to
the
know,
reaction from
I
the
wanted to
brother was,
actually see it.
"Oh,
So
that's
we
just
did
my
open
dad."
records for every single
Wait a
district
minute.
attorney. We have received responses from
You
almost all of them. There's only a couple that we haven't.
Are
but I
telling this cop,
that those
"Oh,
would
that's
be,
just my dad." Well, that's a
big
problem.
factors, the few that were remaining.
That's a
I think
major
was
problem. Why
justice.
is it a major problem? Because
But
the
I
reaction
talked
was
to
not
two of
indicative
the prosecutors
of
in those
how
districts. There's
someone
only
would
two
act.
that actually used
I also
something
learned that
akin to this.
not
and
only have there
one of
been
them said they haven't
reports
done it
that there
either,
was
so
some
they
kind
have
of
done it. And
issue
they paid
with the
between
with the
$40 and
mother
$50 an hour,
and the
which
father.
tends to be
But what I'm told is the
going rate
father
for,
had a whole nother
appointed
family
counsel. It's between $40
back
and $60
home.
an hour, I know, for appointed counsel in
So
those counties.
this is
And then the other county
by
that did use
far
it, they use a part-time
not the
solicitor,
end of the story.
and that
It
DA
may
said
be the
every
end of
time
the story
they would
from
have
the
maybe
trial
some overflow work,
perspective,
an appeal,
but
something that they had extra work
They
to do, they would
they
hire this
from
part-time
what I'm
solicitor.
told
So it was someone who was
that
already a
they've
government,
pinged
government
located. Let me
employee,
not
and
use
they
that
would
word.
pay
They have
$45
located
for this person to do
where
work.
the
So
mother
those are the
and
only
the
people. This is a very unique to Fulton County, which
son is at.
I assumed, but I didn't know.
But it's too
until I
late
did the
now.
research.
There's no need for
Nobody
them
does
now.
this but Fulton County.
Now the question I
And
have
the
is,
AG's office does it, and so we
does
had a
this
lot of
guy,
arguments from
Austin
the state about what the
Chung,
Attorney General's office does.
realize
That's a
the
whole different
magnitude of
It's
what
not
he
even the
just
same
pled to.
section. So the Attorney General is
And I'll
authorized
also
because
say
they
that
represent all of the state agencies. They are
This
authorized
guy might off
to
himself. I
hire
hate to
outside
say it,
counsel,
but
and they have to because there's a lot of
I'm
conflict
getting the vibe
issues.
that this guy may even kill
And so
himself.
it makes sense. So you've
I
got
mean,
different
he's not gonna
needs
sit in that
for
prison
hiring
for
outside
86
counsel. You've got
years.
conflicts if there's a conflict.
And
And if
I
there's a
don't
conflict,
think
you
that
have to hire someone who's outside of the office.
that's how
You
he's
couldn't
gonna go
hire
out.
someone like
Because he
in
was
this
too
case, like
freely to
Mr.
take
Wade,
the
to be
accept
special
the
counsel
86
because
years.
they're in the office.
I don't
So
think
you
he's going
can't-
out like
when you have
that.
a legal conflict, you have to have.
I don't think he's going to
offices
go
have
and
to be
spend the
separate.
rest of his life
So
in a
with the
penal
AG,
institution
that's usually what happens.
and
Sometimes
be
it's
abused
specialized
by
knowledge.
these
I mean, you've
inmates.
got people who are representing commissioners. You know, you've got people who are representing, you know, people in certain agencies in the state in certain types of power.
I never
And
said
so
rich
it might be
people
a specialized
problems. I
practice
never
area.
said that.
So the attorney general is
Um,
authorized, and they actually publish
I
it
never
on their
said
web-
that
on
it's
their
a
website,
tragedy.
all
Someone
of the
lost their
rates.
life.
It's very transparent. So I went through and looked at
And
everybody's
the
rate.
jurors
I mean,
weren't
it's
even
very
100%
transparent.
as to his
How
guilt.
much they pay, it's based on experience.
They
get
know this now.
approval
They
for
weren't
that, they get
100%
approval for
as
the
to his guilt. The
appropriations
judge
for
went
it.
back to talk to the jurors,
And it's
and then
extremely
the
transparent.
prosecutor
Which
and
is
the defense attorney went
indirect
back to talk to the jurors.
Contradiction
And
to
that's
how it's
that's the
supposed to
consensus that I got,
And
that
you-
they weren't
you
100%
know
for his
how
guilt
many judicial
sentence.
districts we have in
So the
Florida. I
question
don't.
now
I
is,
do not.
had he went to
I
trial,
could look at my
would they
open
all
records
voted for
request.
guilty?
So
Would they
the,
all
the,
vote
the
guilty?
judicial districts,
Not
the district
because
attorney
jurors
changed
wanted to
that.
hear from the mother and
so
the
those are
brother.
who I sent all of
This
this
is what I
It's
was told.
over
The jurors
59.
wanted
it's,
to
Like
hear
it's
from the
over
mother and the
50.
brother.
I think it's 59.
Well, they didn't
but
get
I'm
the
not
opportunity to hear
That's
from the
what I
mother and the
positive. I think
brother.
it's 59.
So now
out of
what?
those 59, you reached out to all of them to
Now
see
what?
if their
What's
district
gonna happen
attorney's
on Friday?
offices for each
'Cause the
judicial
judge is gonna
circuit ever
sentence him Friday.
utilized a special assistant, you know,
So it's a
outside
rich people
counsel.
problems.
Yes.
And out of those, only 3 of them.
Yeah,
have
this
ever
is
done
this is
Only
one of
two.
those who
Only 2 had ever done it.
Fulton
who really did it. He
Only
pled
2 had-
guilty.
well, oh,
He
yes, I'm sorry.
admitted
It's
to
3
you
county
know
Fulton
doing
County.
it.
I
But
did not
what
send
is
an open
the
records to Fulton County on that.
underlying
because I knew that they
reason?
did it. So
Is
yeah,
there
What
a
is the reason?
statute that authorizes that?
What
there
is the
is a
reason?
statute, and I cite it if I may. I cite it in my
Yeah,
brief.
feel free.
Okay, thank you. I don't want to
Crazy.
quote it. Let's see.
It's crazy. So yeah, I'm still
it's
downtown. I'm still
15-80-20.
at the courthouse.
And how I
And
came
I
to
told you
learn that
guys
is
I was gonna
actually
do it.
contacted
I
the
made it.
prosecuting
I
attorney's
made
counsel,
it there.
early on in this case.
I made it there.
Because I was trying to figure out the legality of this. You know, I did open records.
Let's
and I found
see
out
here.
how much money the special counsels in this case were being paid. And there's
Wow,
about
this is a
20
case.
different
This is a
people in
serious.
Fulton County
This
who
is
are
a
paid under
serious
this type of arrangement.
conclusion
It's the
to this
largest,
very
personnel
awful
budget
tragedy.
item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what
Also, it was a lot going on in
my
this
opinion,
case.
obviously, I think that's what should happen. But the reason
Yes,
that it
let me
wouldn't
see here.
happen is because if you're
Guys,
hired
what did
as
I
an
miss?
assistant DA, you
I
can't
couldn't
do
really
private
talk
work.
in the courtroom,
So
but
the statutes, and they're
I was
all in
reading the
that- They're
comments.
all in section 1518, 15-18, the one that
Okay,
gives
let's
the
see.
authority for this.
ladies
is
and
the
gentlemen,
one
we're going to take it to the.
but all
We're
of
going to
those,
take
if
it
you
to
read
the
all of them,
other
it makes it very clear that if you're going to
other
hire
courtroom
more
now,
assistant
and let's
DA,
see what's going
they
on
have
here.
to
I
be
want
paid
to see
the
what
statutory
Ashley's
rate.
talking about.
So you can't
Let's
just
see what
pay an
Ashley's
assistant
talking
DA
about.
anything you want. You could not pay them $300,000.
Come on, Ashley, what are you
So what
talking
is
about?
that statutory
It's
rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between 100 and 150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special
many?
prosecutors?
No, how many assistant district attorneys?
No, I actually opened records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county, and I do know I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer though. Depending on who you are in Fulton County, depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate, they monitor the bills, they do all of that stuff. So that's what happens at the county attorney's office.
Okay, county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole nother issue. But so the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say
what I'm about to say. I want to thank you guys for tuning in. I am heading out. This has been a long day. I'm happy to been able to oblige you. With that said, we're going to end this live, and we're going to reconvene later on when I have an update on what is happening in this hearing. I'm going to head to the state capitol right now and see if I can get some questions asked regarding this particular hearing. With that said, ladies and gentlemen, I'm going to end this live, unless you guys have a question. If not, we're gonna end it. We're gonna end it right here.